Page.
1 to 8.
Give only memos, mention memos kindly give. Tele. अच्छा. 50 page तापर orders तापर notice. 1 to 8.
1 to 8. Page 2. 9 to 17.
Item 9, I pray for
Yes.
the
So Parth.
Yes, ma'am.
Yes, Partha. What do you say?
Lord, as per my instruction, there's some
I should not distort your name. Yes.
there's some sort of compromise is going on between the parties.
You want adjournment?
Yes.
This is fresh admission.
Yes, brother.
Adjourn date कर दो.
Need for that.
We commence फिर इसमें कौन? They have impressed. हाँ. So जहाँ date पूछे तो we commence. Yes, yes.
Page 3. 18 to 23. Page 4. 24 to 27.
Item number 26, my lord.
Yes, please.
In this case, I am appearing for the opposite part number 3, that is the President and Secretary of the Honorable Officer. They have to file an affidavit with regard to a particular resolution.
Is there order?
Yes.
Okay.
Lordship may kindly peruse the order dated 17/12.
So there is an order according to you.
So now since the election process has started.
So you take adjournment. Yes, I got your point. You are saying that it's either, it's the borderline.
So they doesn't want to pass any resolution. They want that the new body.
Maybe with try to resolve it.
They have filed an affidavit. Already they have filed an affidavit. This court wants that a better affidavit to be filed.
You take care of that.
Yes.
You should good officer. Of the juniors. The juniors at times they don't agree. Get कर दियो.
We can say code sir.
Your Lordship,
Just one second.
28 ରେ election ଅଛି।
March 28.
March 28।
ତେଣୁ
ନୂଆ ବଡି ଆସିଲେ
ନହେଲେ ଆପଣ ମେରେ କରି ଦିଅ। ସେ ଅଦର ସେଟ୍ କିଏ? Yes, madam. Yes, she's there. Yes.
Yes, Your Lordship.
I was looking for you.
Yes, Your Lordship. Any day.
Change your name to Rajat Gupta.
The petitioner's name is. Yes, sir.
Your name is, I'm sorry, just forgot.
Arjana, Your Lordship. Ruprekha Jana, Your Lordship.
Ruprekha, yes. Yes, sir. In fact, I think the problem since yesterday. Ms. Naidu was arguing that was breaking up. कौन हमारो कहीं की नेटवर्क की सुकालिटी होची? Now she has frozen also.
बहुत इशू आगो यहाँ बहुत गैस मिलगा बहुत
Take charge.
Yes, Your Lordship.
Because this is transition phase.
In Your Lordship.
So you go to April. May
Yes,
first week.
Indeed, Your Lordship. The interim order is there, Your Lordship.
चारी में अपन टिके ता देखंतु आजी एबे कोया पे कोन एबे कले पूरा कटि गले गला परे ओ सबु कोट रे अपन पर अछि रेलवे हम रेल अछि रेल कमर लगु नांती we have two actually both research and retail डेट कर दे पुष्टि कर देबे यस चाइल्ड प्रेजेंटेशन नोट कर दियंतु मिस रूपरेखा जेना petitioner on behalf of LK Marana for the petitioner Mr. Arijit Misra for the opposite
OP number 3 and 4
OP 3 and 4 the matter being in the list is mentioned as agreed by the council for the parties 26 रे मिस्टर लेंका आपण अछन स्टेट कार असाइनमेंट कहि देबे आपण गोटे गोटे असाइनमेंट नते एक्युरेट एमती 26 टा कार अछंती की अछंती कोन ले It shall be listed in the week commencing केते कहले 4 मई 2026.
Much obliged.
Mr. Anshuman Sethi. One होचंदी Anshuman Sethi.
1 or 2?
Sorry, नहीं, I'm actually खाली one. विनोद कुमार मिश्र के ओके. ये अपन तो 3-4 प्रेसिडेंट और 4
Secretary.
Anshuman Sethi 1, Mr. Arijit Mishra 3 and 4. Okay.
Interim orders are there.
Interim order has passed orders and got to the next state of hearing.
Okay. May be permitted to make CLM 28 your lordship.
25.
Yes. As per your lordship's direction, we have deposited 50,000 rupees. As per your lordship, dated order dated 17/2/2026.
Okay.
We directed to deposit 50,000.
Okay.
And next.
So interim order to be confirmed rather. Condition has been complied.
Yes.
So I'll pass that order.
We'll deposit another 15,000 and the interim order.
अपन नेक्स्ट केबे कोचन डिपोजिट करी
20 तारिख भितर जो ऑर्डर अछि
अछि
एटर अछि
20 मार्च सुधा
20 मार्च the order of paragraph number 16 17/2/2026 lordship fixed that date.
Okay. So what do you want? Do you want adjournment to
Well, yes.
that order that you are that
Yes.
deposit? ଆପଣ ମନ ରଖୁନାହାନ୍ତି ଆଉ yes Anshuman. So I'll pass the order. Things Mr. did a simple adjournment but little bit complicated, so I record. I'll pass the order when the matter reaches.
My lord, I am for OP3
OP
corporation.
On behalf
Mr. Alta Singh, you are Mr.
SR Behra.
Mr. S.R. Behra.
the interim order for continue.
Reaches
Manas.
କହୁନାହାନ୍ତି ଆପଣ କେବେ ଆସିବ ଡେଟ୍
13/4.
ୱିକ୍ କମେନ୍ସିଂ 13/4 କହୁଛନ୍ତି. ନେକ୍ସଟ ପେଜ କଲ୍ କରନ୍ତୁ.
Item 5, 28 to 33.
Item 28 minor.
28.
28.
Yes, sir. 28. Yes.
Santosh Kumar Swain. 2 weeks time may be allowed to file reply to the so.
Reply କରିହବନି. এটা adversarial ନୁହଁ ନା. You must understand. You must guide me correctly. Contempt application is not an adversarial proceeding. Then petition, so cause, ସେଥିପାଇଁ counter ବି ଲେଖା ହଉନି. So cause is between the court and the contemptor. I don't have a scope to invite people to comment whether it has been complied or not. That is how, in fact, there is no appeal. It has to be before Supreme Court. You must understand. Please always be guided by basic fundamental legal principles.
Yes, man. 2 weeks time.
So you suppose now I entered kind of things. So then you are filing what it will be called objects. So cause let us say rejoinder. Then you will file then you will file sure rejoinder. It goes on. Scope of interference in a content matter clearly said. Court cannot touch the merits. Either with the contempt, alleged contemptor. Here it is alleged contemptor. It is complied. Now you have to read the sequence of partial compliance. All those aspects you have to examine. This is not a writ application where I will go on entertaining pleadings and go on adjudicating whether this way or that way. One thing is sure, you can always challenge the order on merits. You can always challenge the order on merits. That gives a scope for you and for me to adjudicate also. Legality or otherwise, the order is always open to be challenged.
Yes.
Or just simply
Commencing 13/4.
at times what has happened actually, though we are blamed for pendency, all of us, stakeholders. But at times these matters should not be pending. So if one matter is disposed of, another matter is taken up. Yes. Quebec the data कह दियो.
We commencing 13/4.
Posting है.
36, 34 to 37.
My lord, item 35.
Please.
Let it be to chapter to 5 count.
Learned Counsel, Mr. Gyanananda Panda said that I was not informed. He said, I'm just saying, giving example, this should not happen. I said ki when the matter is, and he said that I listed the matter after much effort after so many years and without this date known to, but make it a point to inform the learned counsel who is appearing for the other side, petitioner or opposite party before you make a mention. Date कहले ना भी.
Full council 13/4.
Yes, next.
38 to 40.
Item 38.
30, Mr.
In order to continue.
No, actually you are mentioning for a matter, but you must make it a presence because union is not like Mr. State is present. Union is not present. You talk to the learned counsel. No difficulty, but develop these healthy practices. They don't know the interim order has been extended and the matter is adjourned. Date confirmed, but joinela pore kohibe.
Right.
Full council 40.
Code itself.
Just inform Mr. Rupla.
Yeah.
Item 1.
My lord, I'm on behalf of the petitioner and filing a withdrawal memo.
Okay.
Actually, both the parties are now staying and leading a happy conjugal life. So they did.
I mean, that's a welcome development.
So,
I mean, that's a very welcome development that I mean, we have at least agreed to proceed in that. Your name, madam?
Aishwarya Prusti.
Miss Aishwarya Prusti, on behalf of
Ravindra Kumar.
Ravindra Kumar Prusti. You are the daughter. Oh, welcome.
Thank you.
Okay. So I mean, you are the only, child or?
No, I have a brother.
Okay. He is not into the
So
profession.
he is an engineer.
Oh, achha. You are the younger one.
No, I'm the elder one.
Oh. Mr. Prusti doesn't look that old. Yes. This is Aishwarya Prusti on behalf of Ravindra Kumar Prusti for the petitioner. You take your seat, I'll dictate the order. It'll take some time. The petition was presented in the year 2013. President of date lecture. Your Nakariki on 8/3/2013. Notices were issued by the division bench on 11/4/2023. Date was the bold 11/4/2013. देखिए हुए हो? Upon change of the determination of the courts, the matter was listed before the coordinated bench and notice was issued after 9/2/2015. Thereafter, the matter has been listed once on 14/2/2020, 14/2/2020, and has been adjourned. The matter is listed under the heading or referral to the special mediation drive, mediation automation. Quotation sorry. Memo of date is filed by the learned counsel for the petitioner. Which states thus: the memo is taken on records. Disposed of. The record document.
Item 2.
Oh, yes.
Yes, please. The matter is listed under the heading so and so. Petitioner none, opposite party blank. The matter was presented before this court on 4/3/2016, 10 years back. Thereafter, it was listed on 21/7/2016. The coordinate bench granted time for removal of defects within 2 weeks. The matter was taken up before the National Lok Adalat on 9/9/2023 when no one appeared for the petitioner. Again, the matter was listed before the National Lok Adalat on 9/12/2023. So 11/5/2024, 14/9/2024. On all the occasions before the National Lok Adalat, and no one appeared. Apparently, the petitioner has got interest in prosecuting the matter. The matter shall be listed. Listed on 16/3/2024, indicating in the cause list that under the same heading, indicating in the cause list that the matter is to be disposed of. Stop. If it would be possible, the registry shall intimate this order and the next bit of listing to the learned counsel appearing for the petitioner. The phone number तो not थिला ना देखिए
Item 3.
petitioner none. दुई भलिया petitioner none. The matter is listed before. The matter is listed today under the heading so and so, so and so. The matter was presented before this court on 8/8/2018. And was listed on 27/11/2018 before the coordinate bench. None appeared for the petitioner and the matter was adjourned. Thereafter, for the last more than 7 years, the matter has not been listed. None appears for the petitioner and the matter is taken up today. The matter shall be listed on 16/3, indicating in the cause list that the matter would retain in the position, its position in the list line article. Listed on 16/3, indicating that the matter will be listed, shall be disposed of.
Item 4.
Very possible, if it would be possible. It is the Pancharan Pani number of people. But his known face. Maybe the brief transfer.
Item 4.
Petitioner none. The matter was presented before this court on 17/7/2009. And was listed before the listed on 29/7/2019 before a bench, before a coordinate bench when it was directed the matter shall be listed before the assigned bench. Stop. Thereafter, it was listed on 14/8/2019. 28/8/2019 before the assigned bench, and none appeared on behalf of the petitioner. For the last more than 6 years, the matter has not been listed. Then send. This over set. 17 कर देना 17 कर दे 17/3
Item 5.
May,
to Saubhagya Kumar Das for the petitioner. Yes, Mr. Das.
my lord, here, my lord, the wife and minor daughter, my lord, filed a case under 125 CRPC
Yes.
before the Court of Law and Judge, Hon'Ble Court, Raulkela.
Yes.
There, the Law and Judge, Hon'Ble Court, Raulkela, while not granting the maintenance to the wife, granted maintenance to the daughter 10,000 per month. Being agreed, my lord, I have filed this application.
Deposit, pay that amount for the minor daughter.
My lord,
Because school.
minor daughter, I have to pay, my lord. Your lordship kindly see the prayer. She
So
made,
you are not following the law actually. Me looking at the prayer, usual submission is my lord is not seeing the prayer, not listening to us. My difficulty is the lawyer is completely out of place. He's tentative.
I pray, my lord, have my
Did you watch the final? Did you watch the final 2020?
my lord, no,
You must watch that actually.
my lord, here,
A ball bowled by Jofra Archer, one of the fastest at 147.
Right.
It's easily flicked over the point. So that requires some preparation and concentration. Most of the time, the discussion is completely off track, out of context, no facts, no law, nothing. Now, suppose you are saying the best submission you can make. Suppose I would have been at your place, may not be as good as you. But my submission is that the court has not taken note of the evidence on record or not considered my pleadings or the material on record. That is the only possibility. Fair enough. Then, for mother, it is not there. Minor daughter,
yes,
there is no such provision to deny her.
Right.
Even if assuming that you can deny her. You secure the decree.
I am not also denying. My lord, I pray
You secure the decree.
at least 5,
So that's not. The problem is, Mr. Das,
my lord.
this is not at the choice of the lawyer's perception or the court's perception.
My lord, that,
This is a material of evidence.
my lord.
So if you have adduced enough evidence,
My prayer
for the
higher side, my lord, that's why I have.
higher or lower, if you have to say, in many cases, the Supreme Court enhances the alimony from 20,000 to 50 lakhs.
My lord, and-
Sorry, 20 lakhs to 50 lakhs. It happens.
Yes, my lord. And
Is it that the Supreme Court is taking fresh evidence? So it has to be a material based on record available. Then please check Samima Faruqi, where the Honorable Justice Deepak Mishra, his Lordship then was, he has said that how this court will proceed. It is not something very, very unique or very difficult, law. Very simple. So if you want 5,000, but if at least secure the decree, how you have paid, keep on paying till they appear 10,000. So those instructions you obtain.
my lord.
Yes, now you say what you want. If I have not touched that issue.
Your lordship already,
Okay.
my lord.
Yes, yes. Take your seat. I'll just dictate the order. You obtain that instruction, then come back.
My lord.
Now the problem is that after you feel that this is a very correct proposition,
My lord.
he will deposit. Then he doesn't listen to you.
My lord.
Repeated adjournments and the pendants increases. So let him take a
No,
call.
my lord.
If he want to take challenge, if you want to challenge, that is, he should keep
My-
on paying till they appear.
Only one date you will.
And it is very difficult. It
My
is
lord.
very difficult. We don't find any law that the minor daughter will
Yes,
be not be
that-
paid.
My lord, I am not disputing, my lord.
Then suppose there is a variation, evidence has to be taken. There is a provision inbuilt in 125, 18,
Yes, my lord. That one.
18 of adoption and maintenance, 25 is the provision. Every law actually,
there.
every aspect is taken care of by the statute itself. You take a seat, I'll dictate that. The petitioner is the father of the minor child. Before this court. ଆପଣ deny କରୁଛନ୍ତି ନା କମେଇବାକୁ ଚାହୁଁଛନ୍ତି?
ନାଇଁ ମୁଁ କମେଇବା ପାଇଁ ଚାହୁଁ ସେ ତାର ପ୍ରେୟାର ଥିଲା 5,000 ତ ମୁଁ କହୁଥିଲି ସେତିକି ର।
ଆଚ୍ଛା। ପଢିଲେ। Either of a minor child who has been made the opposite party represented through the mother guardian. The mother guardian has been made the OP number 1, and the minor child has been made OP number 2. The petitioner challenges the petitioner seeks revision of the order dated 18/10/2025 passed by the Lord Judge Family Court Rourkela in criminal proceeding number 27 of 2024. The criminal proceeding 27 of 2024 was filed by the wife in the marriage and the minor girl child born from the wedlock, seeking maintenance under Section 125 of CRPC. So the Lorette Court, the Lorette Judge Family Court, by the judgment, did not allow the prayer for grant of maintenance to the wife. However, rupees 10,000 per month was directed to be paid to the minor child, to be paid for the minor girl child from the date of application, it is 28/3/2024. Stop. Para, in view of the judgment rendered by the Honorable Supreme Court in Rajneesh versus Neha, and the subsequent and reiterated in the subsequent several decisions of the Supreme Court as well as this court, the amount awarded under Section 125 of CRPC is in the nature of a money decree. The Lorette Counsel for the petitioner has adjournment to obtain instruction to sustain the challenge, how the petitioner will secure the decree. List in the week commencing.
Not 10 days after.
List for fresh admission in the week commencing.
30 Item 6.
357টা ହେଲାଣି. Yes, please.
Item 6, I pray for one Passover on behalf of Mr. Samantray. He's on his
Okay.
legs, Lordship.
Okay. 6টা ପାସ କରିଦିଅନ୍ତୁ.
7.
May I please, please?
You are Mr. Behera.
Yes,
Mr. Khogeshwar Behera for the petitioner.
my lord, the petitioner is the husband, my lord, and the OP filed a transfer petition in the court of Family Court Khordha. OP filed a petition under Section 144 of the CRPC in the court of Family Court of Khordha. Now, though the petitioner is a daily wages worker, my lord, and is not
So which provision empowers me, High Court, to transfer the petitions where daily wages are opposite parties to the place where they like? Which provisions? Sir, this is not a common room conversation. So this is, you are approaching a High Court. At the level of High Court, there should be some discussion which is legally nuanced and some sensible. It should make some sense. We can't be, I mean, this can't be the one sweet will. My perception is also like that. Daily wages, it should be the nearest court, maybe to next court. Or maybe my perception is that for a daily wager, the court should come to his place. He need not go to the court. But can I? Now the question is that, do I have the power under law or any provision is made for daily wager? You must understand that, if somebody is a pauper, he has to apply for that. He can seek legal aid. That is the purpose. Because the Legal Aid Authorities Act does not provide that the court will go to the place. It says that he will seek legal aid.
Here the distance.
And have you checked the marriage video of the daily wager? Yes. Whenever a client comes to you, at least you ask him that you show your marriage video. So I'll be ensured, because I'll argue in the court that you are a daily wager. So here it is not like that a sympathy or you are on a, I mean, I have found out the word in Hindi. दुख भरी कहानी की कहले बहुत दुख भरा कहानी कहिबे तार लीगल सॉल्यूशन अपन काम हैला एज ए लॉयर यू फाइंड आउट ए लीगल सॉल्यूशन एंड इफ यू डू नॉट हैव टेल टू योर क्लाइंट दैट अपन डेली वेजेस पे सेपरेट कोर्ट प्रोविजन नहीं.
Now here the petitioner live in district of Puri, and the distance.
पिटिशनर ପାଇଁ जो पुरी रे रहउचंती कि पटना रे रहउचंती कि मे बी some other P like प्रयागराज रे रहउचंती सेटा को प्रोविजन आपनकर अछि 144 जो प्रोविजन ता सीआरपी अछि बीएनएसएस. So which is the provision dealing with the territorial jurisdiction? Yes, sir, boy dun ऊपर दे and look 144 how boy it's a provision there पतला वाला अछि ना मोटा ओके मोटाटा गेम मन आपन and you must understand that 144 yes. So 144, do you know, have you examined, sir, which is the provision that provides for jurisdiction? It remains unchanged. Earlier provision was
125.
125 has been renumbered, but it remains completely unchanged. So can you find the object and reason of 144? Now look at 145. The boy objection is time only question. Maybe more अच्छी पाइन पचत. 145 पढ़ो तो unless you read it aloud, how do I know what you are looking at?
Proceedings under section 144 may be taken
So
against any person.
miss any word while reading a statute. Never miss any word. 145 starts procedure.
Yes,
Yes. So that is the procedure.
yes.
Proceedings.
Under section 144 may be taken against any person in any district where he is or
So now you have got against any person in any district.
Right.
The A where he is or
where he or his wife resides.
so now B is completely satisfied.
But here,
So it is so the separated words are or. So this is your answer you should give to your client, not come to High Court by filing a. If you want any legal aid, that you can seek. Whether you are entitled or not, that's a different thing. And you can seek for appearing through VC. Nowadays, after ICT initiative, there it is there.
that's That should be better. Here the petition may be directed to appear through VC.
No, I cannot direct. I'm not the magistrate. So these are the things which he doesn't know. He says that you go to High Court and I'm not the magistrate. The petitioner has to file an application before the court that for these reasons I will appear in VC.
Your Lordship, another-
You were present in the beginning when the mention was made. Lord Counsel said because now airspace in Middle East, East Asia is completely closed. I mean records it also. Thereafter, in a 1 second, I'll just or fraction of a second, I mean nullify everything. Pre-conciliation meetings, pre-conciliation discussion. Even we are at High Court, you are attending, we are doing that.
ସେଥିରେ ସାର୍ କଣ ହେଇଛି ଗୋଟେ
ସେ instruction ଟା ଆଣନ୍ତୁ ଆଗ.
ମୁଁ ଆଣିବି
Because that plea is sufficient. If what you are saying as per your instruction is correct, that the suit schedule property is in your name and you are a shareholder.
yes
Through your predecessor in interest. So ସେଇଟା ତ ମତେ ଦେଖିବାକୁ ପଡିବ. I have to record that.
ଆଜ୍ଞା 25/1/2021 ରେ ସେମାନେ ପିଟିସନ ଫାଇଲ କଲେ ଡିକ୍ରି ହେଇଗଲା 19/2/2021
ସେଇଟା ତାଙ୍କୁ ଦୋଷ ଦେଇ ହବନି. କାହିଁକି? That is our effort. We are making a Herculean effort to achieve something in Lok Adalat, especially because civil suits for continuing for generations. People are passing away without enjoying even that is worse than a criminal case.
that happening but in some
That is the effort of if I am not the administrative judge of Singhpur, but this is effort for me, for my district, that I ensure that civil suits are taken up and disposed of if the parties agree.
at least ସେ ଗୋଟେ ଖାଲି ଲାଗିବା କଥା
Everything is been done by the procedure, whoever the judge takes care of it. Then suddenly somebody crops up and says that I am not a party, so everything goes. Indirectly, disposal of a litigation has ended up in more litigation.
ଏଇ ସବୁ ଇସ୍ୟୁରେ
The entire effort is
ଝିଆଳିଆ ଅଂଶ ଯୋଉଟା ସେଟାକୁ ସ୍କିପ୍ କରିଦଉଛନ୍ତି ଫାଇଲ କରିଦେଇ ନେଇ ଯାଉଛନ୍ତି ତାକୁ ପକ୍ଷ କରୁନାହାନ୍ତି ସେମାନେ ବି ଜାଣି ପାରୁନାହାନ୍ତି
Sir, nowadays people are really skeptical about civil suits. They are really skeptical. For generations together, they are skeptical. 50 years, 40 years.
ସେଟା ତ ସେ
It is so much actually for properties like Bhubaneswar where cost my senior interested me. I was only assisting. Another senior. They are very, high profile, high stake properties in Bhubaneswar. And one day my client told me that father passed away. Elder brother is almost, he's suffering from so many diseases. If I would have concentrated in my business, I would have won much more.
ସେ ସବୁ
But Kharbel Nagar, Bapuji Nagar, these kind of places, when they start fighting, it goes for generations. And they are the past generation in Bhubaneswar, they have so much of property. There is some dispute regarding adoption. That led to this kind of complicated suits. So that is the reason people are opting. My point is, you cannot find fault with the petitioners that they went for any disposal before the local adalat. That cannot be the criteria of assessing. We examine it. Mr. Niranjan Lenka election, Mr. D.N. Lenka for one. It is submitted by the. You kindly take your seat. I'll just take some 2-3 minutes to dictate the order.
Man.
Is submitted by the learned counsel for the petitioner that the petitioners are recorded owners. ଆପଣ recorded owner ବି କହୁଛନ୍ତି ଆପଣ ନା record ଅଛି
କିଛି ପ୍ରପର୍ଟି ଆମ ନାଁ ରେକର୍ଡ ଅଛି
5763 is recorded owners of some properties
yes
which forms part of the
no that is not the part of the suit my lord ସେଟାକୁ ସେ ଦେଇନାହାନ୍ତି ଫ୍ୟାମିଲିର
ତାହେଲେ ଛାଡି ଦିଅନ୍ତୁ ଆପଣ ନିଜେ ଆଗ ସାଟିସ୍ଫାଇ ହୁଅନ୍ତୁ ମତେ ତାପରେ କହିବେ
but I am satisfied I have drafted the brief
I understand ଆପଣ ଖାତାର protocol କହିଲେ I am not going to issue notice because the problem is that if I say that now
my lord I said that in some properties our name are there being the shareholder so in
ସେଟା ତ at least the minimum demonstrate କରାଯିବ ଏଇ କୋର୍ଟ ପାଖରେ to interfere ଗୋଟେ ଫ୍ୟାମିଲି ଟ୍ରି ହବ,
two series by
ଗୋଟେ 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 ଫ୍ୟାମିଲି ଟ୍ରି ରହିବ, ଫ୍ୟାମିଲି ଟ୍ରି ରେ କାହାର କେତେ ସେୟାର ରହୁଛି ରହିବ, କୋଉ ଖାତା ପ୍ଲଟ ରହୁଛି ରହିବ, ସେତିକି ତ ରହିବ।
ମୁଁ ସେଟା ଗୋଟେ paragraph 3 ରେ କ୍ଲିୟର ଲେଖିଦେଇଛି। paragraph 3 ରେ କ୍ଲିୟର ଲେଖିଛି।
ନାଇଁ ଆପଣଙ୍କର ଯୋଉ କହୁଛନ୍ତି, ଆପଣଙ୍କର ପାରାଗ୍ରାଫ 3 ରେ ଆପଣ ଯୋଉଟା ଲେଖିଛନ୍ତି ଭର୍ସନ ଅଫ ୟୁର କ୍ଲାଏଣ୍ଟସ୍,
ହଁ
your version of your client can they agreed by the year they are challenging that distribution.
annexure 1 ଟା ବି ଦେଇଛି।
ଆପଣଙ୍କର clientଙ୍କର your clients are agreed by that their property has been distributed to others.
authors
So that has to come up from the schedule itself.
that annexure 1 is the legal heir certificate।
Legal certificate doesn't help. ଆପଣଙ୍କର ଯୋଉ ଫ୍ୟାମିଲି ଟ୍ରି ଯୋଉଟା ରହେ ଷ୍ଟାଣ୍ଡାର୍ଡ ପାର୍ଟିସନ
General
ସେଟା ରହିବ, ଆପଣଙ୍କର କୋଉ ପ୍ରପର୍ଟି ଇନଭଲ୍ଭ ରହିବ। If the lauded permanent and continuous local adalat either it was not aware, maybe it was
Yes.
not made aware because they were not.
yes
So that has to be reflected from the records. It is a serious challenge. So that you do. This property is mine and this has been distributed. Now Mr. Lenka, possibly, suppose there are 10, 50, 5 properties belong to them that has been not touched by the permanent local adalat. 10 properties have been touched by the decree of the permanent local adalat. So I cannot interfere for those 10 properties. They have to assert that out of the 10 properties, 15 properties, 5 is in our name. Rest 10 properties belongs to us. Those things have to be there. It is almost like a reappraisal of the suit.
yes
So, but it will be remanded.
yes ma'am
MFSA, you have to make out that case. Otherwise, it will be contrary to the decision of the Supreme Court. 3 decisions. I can interfere. The parameters are very clear down.
that's why what I pray if notice will be issued, let them say
I will not issue notice. I'll reject that prayer with reasons. The reason being that the parties who are to the litigation, they have been considered, and these parties, so they could have, I don't know, because in case of in some cases appeal is also maintainable.
ଏଠି ମୁଁ ଦେଖୁଥିଲି
ଜୟଲୋକ ସିଂ ଦେଖନ୍ତୁ,
ମୁଁ ଦେଖିଥିଲି appeal ବୋଧେ
ଠିକ ଅଛି ଯଦି କହୁଛନ୍ତି, since you are saying let us test it. Jayaloka Singh is very clear on this. In some cases, appeal is also maintainable. Not only writ application is the common form, because local writ application. Examine is there. Next time, we have already spent time without, because I am not passing any substantial order. I am just simply adjourning it. But I am trying to tell you so that I can get access from you.
yes sir
I have no difficulty in interfering, but I must be sure of these things.
who is ପରେ ଗୋଟେ ଆସୁ
In Suryavanshi, it says appeal is maintainable. Not Suryavanshi, that builder. ଲେଖା ହେଇକି discord ପଳେଇଲା ସବୁ. What is that? Yeah. This is not the place to start. ନାଇଁ ଭାର୍ଗବୀ ମୋର ମନେ ଅଛି ଯେ, ବଟ୍ କଣ ଉପରେ ଏଠି ଯୋଉ ମାରିବା କଥା କାହିଁ ସେଇଟା? State of Punjab versus Jayaloka Singh is AI 2008 Supreme Court 1209.
I will check out
Then Bhargavi Construction, AI 2017, 4428. ଏଥିରେ ବି ଆପଣଙ୍କର ମୁକୁନ୍ଦ ଭବନ ଟ୍ରଷ୍ଟ ଦିଆହେଇନି. Then look at Mukund Bhavan Trust into bracket 2024 15 SEC 675. So, like, they submitted that the petitioners have interest in the properties that was the subject matter of
P&C case number 46 of
and P&C case number 46 of 2021. Disposed of by the Court of Permanent and Continuous Local Adalat, Kendrapada. The said judgment has been annexed. The copy of the plate has been annexed to the application, which at internal page 4, running page 32, discloses the details of the property. Alright. The application was disposed of on the basis of a compromise petition made by the parties to the said P&C case. P&C case. They submitted that the present petitioners are vitally interested in the said properties. Descendant.
shareholder.
Being shareholders. Para. To demonstrate the said submission, to demonstrate the said submission, the petitioner shall file affidavit giving in tender for comparing the scheduled property, what is that family tree has another term,
Genealogy.
the genealogy, the details of genealogy, indicating their share and development of the property. Para. This in the week commencing, this
These charges.
6-4-20
Item 11.
11 yesterday I took time to find out to which date the case is posted to. And that in fact I could get, but there was something else fell from your lordship whether I should challenge the very original, because I had said that despite the
It's a minor mineral concession rule demand.
but I will have an alternative submission subject to your lordship's kind consideration. I was told by the local lawyer, though he could tell me the date, he has to maybe find out in course of the day, that he has already filed a denial of liability petition in terms of Section 8. I'm only praying, subject to your lordship's kind consideration, that application may be considered by giving me opportunity, because he has to proceed.
You filed that memo because I think he had not instructed you that he has already filed. Right now, after you asked him, he has said it.
No, he has.
Brief doesn't.
Brief doesn't say so. He's a very senior, responsible counsel.
No.
He has said he has filed, and even I asked him for the copy of.
Last your lawyer associate filed that. Because what Mr. in fact Mr. Lenka also picked up my what I said, that if it is there in the pleadings, then fine. If it is
not there,
then,
and
so yesterday I wanted to adjourn the matter for that. I wanted the next date.
He is of the view, the local lawyer.
No, local lawyer would not have filed any writ application before High Court challenging the
denial of liability.
He is entangled in that what is that public PD case. OPDR minor mineral demand to con challenge kori. Anyway, it is his choice. Amar
she kouchundi. मुझे
reasonable opportunity देना हो.
Section 9 also provides that.
Correct. That is what.
ସେମାନେ କଣ କରନ୍ତି ବେଳେବେଳେ ୟୁନିଲାଟରାଲ ପ୍ରୋସିଡ୍ କରି ଯାଆନ୍ତି ତ ମେଲଟ ଅବଜରଭେସନ ରେ ଆଟଲିଷ୍ଟ ଗୋଟେ ଅପରଚୁନିଟି ଦେବେ, ଆଉ କଣ ଅଛି.
Section 9 is very clear.
That is clear. I am conscious of that.
The Samir Misra, senior advocate, along with Mr.
Sir, where?
Mr. S.R. Behra for the petitioner. Mr. T.N. Lenka, additional government advocate for the opposite parties. The matter was listed yesterday and was heard at some length. The length and at length, comma, was adjourned to enable the learned instructing counsel to obtain instructions to apply the court. Stop. Para. It is submitted by the learned counsel, senior advocate for the petition, that the petitioner in the pending proceeding, that is so and so, so and so. In the proceeding under the OPDR Act, TMC case number 01 of 2005.
2020. 01 of 2020.
25 ऊपर भूल होते 2000
It's a case.
नहीं OPDR certificate TMC case number 1 of
Mr. Lenka is differing.
नहीं डेफ को ले बोलते 25 बढ़िया है ये
ठीक अछि हां से सेकंड पेज रे ठीक हे जैछि
आज्ञा
पेज 15 देखंतु
आज्ञा आज्ञा
2025
सेटा 25 के ना 25 रे ही गला डिमांड ता तेनु ता आगुर नंबर
केस नंबर 01 of 2025 सेंटेंस कोन हला और आगुर रे 15 16 थिला
15-16 मोर हैला जोटा पाइली मु लिस्ट तेनु 2005 रो तो नंबर आई परिबनी 15-16 मु पाई कि किछि ऑपरेट
TMC केस अछि पेज 15 सेकंड पारा
पेज 15 सेकंड
15 यस पेज 15 सेकंड पैराग्राफ Arrears outstanding government dues from the lease in connection with TMC number 01 of 2015-16.
हां सेटा तांकर केसी तो बर्तन सर्टिफिकेट गोला ओपीडीआर सर्टिफिकेट हे गेला आगो खाली थिला टीएमसी बर्तन ओपीडीआर सर्टिफिकेट के टीएमसी केस नंबर माने काइंडली
सीधा लिखिबे मिस केस
ओपीडीआर
टीएमसी केस नंबर 01/2025
तार पूरा नाम होछि आगे
has filed
section 8
application under section 8 of the OPDR Act, which is pending adjudication before the appropriate authority.
And adjudication is to be done in terms of section 9, providing opportunity and everything.
And its senior advocate also refers to the section 9 of the OPDR Act, 1962, which provides for hearing and determining of such petition.
And even he can set aside also and everything. That is also provided. Modify, vary.
Which includes the power of powers confirm, set aside, modify
or vary
the certificate. Memo of date is filed by the Learned Instructing Counsel, Mr. Behra, indicating that the application has petitioner,
the certificate debtor has filed here. Petitioner has filed petition denying the liability.
That the petition has filed petition in terms of section 8 denying the liability, which is pending adjudication. The memo is taken on record, scanned copy be updated.
Copy we serve.
Copy of the memo shall also be served
along with the petition. Along with the denial petition.
Denial petition has to be
I am recording his submission.
At least the knows me. I'll not just.
No, sir, even knowing you also, suppose it has not been filed, what can be done?
The order
ask for instruction would line add code. What add code? After instruction received from the Learned Instructing Counsel, who is conducting the matter at the trial court before the authority. Then Mr. Lenka is actually saying something in your favor. You must understand. He is giving a hint. ଆପଣ ଯଦି ଫାଇଲ କରିନଥିବେ ଏବେ ଫାଇଲ କରୁନାହାନ୍ତି।
ଫାଇଲ ହେଇଛି। That is the statement.
So he is confident.
ମୁଁ କହିଥାନ୍ତି I will file and it will be considered. That I can very well say now. That I will file.
I was thinking Mr. Lenka is hinting at that.
ମୁଁ ବି ଦେଇଦେବି unofficially ଯଦି ଆଜି ପାଇଯିବି ରାତି ସୁଦ୍ଧା। Just for his satisfaction.
ମେମୋଟା ଗୋଟେ ଜେରକ୍ସ କରିକି ଦେଇଦେବେ Mr. Lenka। ହେଲା। He also saw AG. In view of the above, no useful purpose should be served in keeping the matter pending when in the OPDR proceeding, the matter is to be considered by the appropriate authority under section 8, under section 9, read with section 8 of the Act. Accordingly, the writ application is disposed of, directing that the authorities are consider the petition filed by the certificate debtor within court certificate debtor denying the liability in terms of section 8 read with section 9 or 9 read with 8 in terms of section 8 and take a decision in accordance with law as expeditiously as possible.
There is a delay also.
Who delay kale sir?
He has to file within 30 days.
সেটা ফাইল হয়েছে।
Acha. If there has been any delay in filing the application under section 8, the same shall be condoned. The same is condoned. The adjudicating authority has not itself on the ground of delay in filing the application. So he has argued the matter.
That's
I'm thankful to my
No, exactly. No, that should be. This is because this is question of law.
yes.
Is it not that the court has a choice to decide because I'm addressed my lord, ମୁଁ ଯୋଉଟା ଭଲ ଲାଗିବ ସେଟା କରିବି ସେଟା ତ ନୁହଁ ନା।
In fact, State Council is to do it like this, my lord.
And we have seen how Justice Patra used to deal with State Council. It was so scary to appear before him.
My lord,
But he had a unique sense of humor actually.
my lord, your lordship is saying out, my lord Justice R.K. Patra. So once a State Council stood up and said,
No, should we I mean, are you sure that because this is live? Sound ଟା ଟିକେ କରିଦେ।
ମୁଁ ଖାଲି ପଦେ କହୁଥିଲି ସେ ଜଣେ ଷ୍ଟେଟ୍ କାଉନସିଲ ଠିଆ ହେଇ କହିଲେ your lordship may direct will I am sorry କହିଲେ
मेमोटा देवे मिस्टर बेहरा अंदर से जेरॉक्स से कर देवे he will help you, he will make a photo.
Item 12.
May please, Your Lordship. Your Lordship, item 12, we filed a writ assailing the order of the Learned Family Court, allowing an order 6 rules.
Your name, sir?
Gautam Mishra.
So Gautam Mishra for the petitioner. Yes, please.
Your Lordship, the order is at Annexure 6. It is an order allowing an order 6 rule 17 application for amendment.
Yeah.
And the amendment is sought for after the commencement of trial. But there is no observation as to whether due diligence has been observed by the petitioner who is seeking amendment by the learned court.
Have you examined this aspect in context of this is not a suit, this is a matrimonial?
Yes, Your Lordship.
So, is there any concept of res judicata in 13 applications?
Your Lordship,
No, please. I'm not against you. While arguing this, if this point when you are arguing, this is a good point in case of a suit. But as far as matrimonial causes is concerned, there is a reason why the amendment should be allowed. Have you thought about that? You must think in those lines.
Lordship, section 10
Because
of the
suppose today a 13 application is filed pleading insanity. I'm just giving you an example, not in your case. Insanity is rejected. Is it that tomorrow that it cannot be filed? Insanity. All the pleas available because it is not CPC. The ground stated in 13(1), 1A, 1B, every ground can be reiterated. So that is how there is no concept of res judicata. Now suppose, let us assume, dejection is filed, cruelty is to be added. Now you take this plea that after the trial has started, how can he grant cruelty? Well, me as a family judge, I will accept your plea.
Definitely,
Then the other side goes to High Court. High Court will say that initially dejection was there. Now cruelty is to be added. Cruelty can be a separate ground altogether. Then what is the purpose of not allowing the amendment?
Your Lordship.
You as a defendant, you are making this plea?
Yes, Your Lordship.
Correct.
Yes.
So now the petitioner will go and file application under 13(1), 1A, taking dejection as the cruelty as the plea.
Yes.
What is your answer to the plea? You have to, can you say that it is judicata?
No, Your Lordship.
So that is the reason this branch is different, because this is the grounds. It is not General Clauses Act, permanent injunction, mandatory injunction, CPC. 13(1), 1A, 1B, whatever 1B, whatever is there, those are grounds which can be taken individually or together. Now, if another point is added, the court suppose court is not allowing, accepts your plea, the insanity cannot be added. Because adding a plea by the petitioner makes it difficult for the petitioner, because he cannot say that I don't have to prove it.
Most definitely, Your Lordship.
And another aspect that is of course secondary, may not be at the stage of, which is the most difficult attribute to prove in 13(1), dejection, cruelty and insanity. Most difficult.
Insanity, Your Lordship.
Most difficult. Second?
Yes. I believe it is cruelty, Your Lordship.
You have understood it correctly, actually.
Yes.
So good. So that is how, if I now take a view, I must say that this plea, which could have been taken at the beginning, cannot be taken now.
Yes.
Because somebody becoming insane in terms of 13(1), 1A, because again, it is not like, what is the test in IPC, insanity?
Dolin Capex, Voidar test, I think. No.
That is that test in McNaughton.
Yes.
McNaughton test. Yes. Dolin Capex is a minor cannot commit any crime.
Yes, yes.
So this is a very specific provision in 13(1). It's a kind of, you have to have a medical board, all these things,
yes.
all these things. So it is better for the defendant also. At least she is not subjected, or he is not subjected to the rigors of the trial.
Yes.
Suppose today you are not allowing the amendment. The suit is decided on the ground that was filed. I'll come back and then I'll hear from you.
Yes.
Today you have to think on this.
Yes.
Okay.
Lordship, only thing is that I want reconciliation. That is why I also made an amendment for mediation, Your Lordship.
Please appreciate this thing.
Yes.
whether it is for insanity, cruelty, or desertion.
Yes.
No court has capacity to refuse conciliation because this is statutory.
Yes.
Only in case of 13B, Harbin Kaur court has power. Still, the Bhubaneswar court is not allowing. Rightly so. You have to have, because 13B says 6 months is mandatory period.
Yes.
But court can exercise jurisdiction. So in one matter, I have directed that in terms of Harbin Kaur, Supreme Court has said that instead of detaining itself, you go ahead. Because for 6 months, it becomes actually a
Yes.
useless formality because they have already separated. They want to get married. Submission was made before me. I remember Mr. Das and Mr. Patnaik that they want to get married. So they are in a hurry. Next month, I am detaining myself 6 months ago. But understand, so Harbin Kaur has also a context. 142 is there. I don't have that power. But upon the argue the amendment should not be allowed. But if it is a plea available in 13(1)(1)(a), then what is the fun of having another round of litigation? So you are not helping your client.
We are only arguing on the due diligence observation.
Due diligence is applicable. That is how I took this much of time.
Yes.
Somebody discovering the wife to be insane after filing the suit on the ground of cruelty or desertion.
On this account, Your Lordship may allow me to point out certain things. Your Lordship.
No, you think in those lines because that is not your approach. I have whatever I have read from your brief right now. I am reading with you only. I have not
Yes.
made up my mind. I am still open.
Lordship,
But since you should spend this time because suppose I accept your contention, that leads to a multiplicity of proceedings. Tomorrow you will file. Now, anyway, I'll come back and I'll let you know. What is the next point? That is a very important point.
Your Lordship.
What is you think about? I'm giving you the third thing. I have said, but I mean, very well you have answered. What this court cannot direct.
Your Lordship may let me one factual submission I'll make.
I will hear you fully.
Yes.
It will be your time only because at times what is happening after you say 20 minutes, then I ask you certain questions, the entire 20 minutes is wasted.
Yes.
So that is how I started at the earliest so that at least on the context we are together.
Yes. Most definitely.
I'll come back.
Yes.
Yes. Next. Second after. Yes, next. Password डाकନ୍ତୁ ଆଉ ଥରେ डाकी दियो
Password item 6.
छाड़ दियନ୍ତୁ କଣ करे देखिए ପରେ देखिए फेर ଏଥରେ से मेंशन करथिले जे हम रिपोर्टर अछंती ठीक अछि नेक्स्ट
Item 13.
एटा सीरियली जाउछन यस मिस्टर महापात्र योर
Item 13 permitted to withdraw. In the meantime, the
कैन यू फाइल योर मेमो
Your Lordship, just now.
कोन सीटा मेमोटा मिस्टर मिश्र लेंका करनो देना दिले मिस्टर लेंका गोटे कॉपी दे मे बी ही विल गेट टू टेक योर सीट आई विल डिक्टेट द ऑर्डर
Your Lordship.
Mr. Sushant Kumar Mahapatra for the petitioners.
Santa Sekhar.
Sushant Sekhar. I missed Sekhar, which I should not. So Sushant Sekhar Mahapatra for the petitioner. Opposite party black. The matter is listed for orders. As the SR has pointed, as the staff report has pointed, as the staff report dated, date for staff report dated 17/9/2021 has pointed that, right, sentence as by the staff report dated 17/9/2021, it is pointed that the matter may be registered as CRLMP. The petitioner before this court is the husband in the marriage. Seeking a revision of the order dated 3/8/2021 passed by the learned judge family court Fulbani in CRP number 66 of 2020. The said CRP was filed by the wife in the marriage and a minor girl child born from the wedlock seeking maintenance under section 1 to 5 of the CRPC. Monthly maintenance. No. Memo of date is filed by the learned counsel for the petitioner. ଆପଣଙ୍କ ନାଁଟା ପୁରାଟା ସବୁବେଳେ ଲେଖିଦେବେ ସର୍ଟ ସିଗ୍ନେଚର କରନ୍ତୁ memo records scan copy be updated copy of this in view of the petition stands disposed of. Copy of this order shall be forwarded to the learned judge family court Fulbani to be kept in the records of number 66 of 24. Yes, next. Hon'Ble.
14,
Nandi orders matter. Yes. Pass on. Mahapatra is not there. Satyanarayan.
15,
It will go to another day.
Notice he has to take. Again, respond now.
That is the reason. That is the reason. In his absence, I cannot pass that.
Only thing they can do address ଟା କେମିତି ଦେଇଛନ୍ତି 5 ନମ୍ବର so and so ଗୋଟେ କମ୍ପାନୀ ନା ଭୁବନେଶ୍ୱର କୋଉ ଜାଗା କଣ ପ୍ଲଟ ନମ୍ବର କିଛି ନାହିଁ.
He may come. I will mark your presence. I am simply passing it over since it is order matter. I will mark your presence. You are there for OP?
OP number 1, 2, 3.
Okay.
1, 2 and 3.
Yes, pass over next.
Oblige.
16,
Item
50 ଅଛନ୍ତି?
yes, my lord.
Sir,
Sir,
say ଅଛନ୍ତି. So he missed it.
my lord. On behalf of Satyanarayan Mahapatra, kindly taken off 1 week after.
अरे नहीं सेटा आपनकर ऑर्डर से आछि. So Mr. Polai, it is for orders taking fresh notice. 5 रे आपण जो एड्रेस ଦେଇଛନ୍ତି.
Yes, my lord.
So Mr. ये Polai at भुवनेश्वर पहुंची जीवो किन से कंपनी रे पहुंचियो कि आपण सन जानछन्ती भुवनेश्वर रे. That he is saying.
सारंग कौन
सार कहले तो आर्डर नोटिस नेबे आपण भी नोटिस नेबे. तान सर कथा होंतु हैला. Come back after recess. But why you will detain Mr. Udgata? For orders, you have to take fresh notice. He's for the appearing for 1 to 4.
1, 2, 3. 1, 2, 3. State is
1, 2 and 3. Okay.
press notice होगा sir.
ठीक है, I don't hesitate to pass it over, but don't adjourn the matter.
Okay.
But अपन भी दीटा पर अपन आलू पठेले. सार पठेले दीटा पर आलू.
No, no, my lord.
बुझी दियो.
Yes.
हैला. तो बुझी कौन?
Yes, my lord.
Yes, you can leave.
Okay.
16,
पास over गोटे वाला शो करंतु.
17,
गोटे का आउथरे कॉल कर देबे.
18,
आपनकर केते? अच्छा, sorry, I am so sorry. I forgot that because there are so many non-appearances. I thought that it is your mail. Jeros करी कि दे देबे गोटे विषय. मतलब कमांड में दे देबे. Yes. आपण कॉल करू आपण फिर अटके लेकिन. अरे आपण अटकुचनी काहे प्लीज कॉल करना दी.
18, 19,
Yes, Mr. Patnaik, what to do? Yes. Achyutananda Patnaik is not there.
2 cases are there. In 1 case, they have filed the members of the
So, since I am passing it over and calling again, so check करो, ठीक है.
20,
20, sir.
Yes.
So Ajit Kumar Tripathi for the petitioner.
Yes. This case relates to maintenance of
You are there, Mr.
Milord.
Panda.
Your lordship has
You are Mr. Panda.
Milord.
Mr. Ajit Kumar Tripathi for the petitioner, Mr. P.K. Panda for the opposite party. Yes. You are saying something, please.
My lord, in the last occasion proposed for remand back to the matter.
Correct. Obviously, I can't apprise that because it requires examination in chief.
And I was directed to instruct some client.
Correct.
I have convinced my client. This.
I mean, that would be fair to both the sides. Yes. Okay. Mr. Basu. 20.
I don't know.
I am at a different rate. Last order केबे हेतला ट्रायल कोर्ट रे को स्टेज रे थिला सेटे पते कहबे we check it and tell me what was the stage and what was the order, last order, if you can, so that will be better. My order will be more clear. But otherwise, I'll simply direct that after you appear in a particular date.
Yes.
With the affidavit will be filed. And same shall be taken up on consider and in accordance with law.
After disposal, they have come.
अच्छा, final पूरा disposal हो जाएगा.
Yes.
चल ठीक है.
That was rejected.
So at the stage of filing of affidavit,
Yes.
consider how. So my concern is that at what stage I will leave this matter. The entire thing cannot be reopened now. Up to a certain stage, even in where the examination chief has been completed.
No.
Everything was over. Matter was rejected.
He was not expertise.
No.
So everything is over.
Merit, it has been rejected.
So both parties have been examined and discharged.
Yeah.
So it will be the examination in chief and cross will be only to the with extent to the this assets and liabilities. That much I can do.
Assets and liabilities, documents not filed, affidavit not filed here.
I'll give some time.
I have already filed this asset and affidavit here.
So the acceptance of the further evidence and document.
Yes.
So that you may identically you will file, or you may add that exactly that affidavit you can file there, but I will not curtail your liberty there.
Yes.
Both of you have the liberty to file that before the trial court.
Matter be targeted also, so that it can be
Targeted
disposed
of
of
Kariyavani, there is a absolute the language used by the Supreme Court is very strict.
expeditiously.
That's what I will say, and both of you will cooperate.
Yes.
Yesterday we were reading again Asian resurfacing. Constitutional courts should not fix time limit for trial before any court. And they had, and the reason is very clear that since other cases are pending, picking up a particular matter is not a. I mean, the equals have been treated unequally. So both of you take your seat and dictate the order. Order dated 4/2/2026 ra. Para 1, 2 upon repeat reproduce कर दे. To be easier for it. Para. By order dated 4/2/2026. The matter was the Learned Counsel for the parties were heard at length. And the following observations were made. Sithi para 3 and 4 quote kar den. The Learned Counsel for the opposite party submits that he has obtained instruction and the matter, though disposed of, may be remanded to the limited extent of considering affidavits of both the parties on assets and liabilities, as cited by the Hon'Ble Apex Court in Rajnesh versus Neha, AIR 2021 SC 569. Para. Accordingly, it is directed that the affidavit by the petitioner as well as the opposite party who are the Petitioner ସେଠି dependent ନା କଣ ସସ୍ମିତା ବେହେରା trial ରେ କଣ ଅଛନ୍ତି?
Petitioner.
ସିଏ ବି ସେଠି ବି petitioner.
Yes.
Who are the
She and her
petitioner?
child.
ସେଠି petitioner and respondent. ନା petitioner opposite party.
Sethi petitioner, ethi petitioner.
The opposite party कौन? Respondent ना opposite party सेठी.
The respondent is the husband.
एठी opposite party, एठी respondent हो.
It is husband.
Who are also the petitioner and opposite party respectively before the learned trial court shall file their respective affidavits in terms of the directions of the Honorable Supreme Court in Rajneesh versus Neha Supra by what time?
Within a week.
Mr. Panda?
Within a week, I can file.
I'm giving you within
specific time.
Shall file the affidavit within ऐसी कितना है उसमें? by 30/3/26.
Yes.
By 30/3/26. Before the learned judge,
Family court just.
Jajpur. They shall appear before the said court, before the learned court on 30/3/26. The learned court shall take up the matter again, fixed date. So, the proceeding shall resume to the extent after remand by this court that both the parties shall have their examination in chief and cross-examination as would be advised.
Yes.
In accordance with law. So, the learned judge family court is requested to take up the matter expeditiously, and the parties are directed to cooperate with the learned court in disposal of the matter at the earliest, without taking any unnecessary adjournments. Anything else?
You may kindly see para 9 of the judgment, the impugn judgment.
କୁହନ୍ତୁ କଣ ମା ପଏଣ୍ଟଟା କୁହନ୍ତୁ ମୁଁ ପଢିଲେ କଣ ହବ ମୁଁ ତ ଯାଇପାରିବିନି ସେପଟକୁ ନା
That nobody has filed affidavit here so far.
Asset and liability.
The Rajneesh versus Neha. But that is the order that the order prayer for prayer under section 125 has been rejected. Prayer under section 125 made by wife has been rejected.
ନାଇଁ ସେଇଟାକୁ ଆପଣ assets and liability ଯଦି ଦେବେ ନାହିଁ ଚାହୁଁଛନ୍ତି 125 is also is not res judicata. ଆପଣ ଯଦି 100ଟା 200 ହେଇପାରିବ କି 100ଟା 50 ହେଇପାରିବ 0ଟା ବି 300 ହେଇପାରିବ. I hope you understand the mathematical model I am presenting. 125(3) is always open. It can be reconsidered. But I think it is better if the entire thing is reconsidered by the court. 125 order can be modified or not?
Yes.
125(3) So now the 125(1) order is 0. 0 is awarded. So 125(3) also is power is there by the court. That is my understanding. So now on remand it will be considered. Actually, I could not get what turns on that. Para 9.
Para 9 that she does.
Say it is a matter of fact that Mr. Tripathi.
No, it was filed by either of the parties.
Either of the parties, it is not disputed. So that is how since it can be done by filing of the parties.
That happened on merit. The prayer of the wife claiming maintenance was rejected.
So that is the reason that the remand is to the extent of consideration of the affidavit.
Set aside should be this judgment.
The order, yes. The judgment is to the above extent. The judgment is set aside and remanded. That because this order will be structured.
Yes.
What I am dictating the essential part, which you will know.
Yes.
But it will be developed and it's more structured as I render the judgment. Yes. Yes, madam. 17. Content passed over. 17 ରେ ଆପଣଙ୍କର ମେମୋଟା ଦେଇ ଦିଅନ୍ତୁ. I'll dictate the order. 17, Mrs. Das, your name is not there. Okay. Just request him to sign the memo. Okay. So, the matter will be called again. It has been passed over only. No. Not necessary. I got your point. You did not be present here. Yes. Mr. Patnaik,
Yes, sir.
your item is? That is just wait because there are some passed over matters. There is for some reason council did not appear. Passed over item.
Mature item 6.
So Santosh Kumar Samantray for the petitioner. Yes, Mr. Samantray.
Is a transfer of matrimonial suit from Puri to
Ground. Straight away come to the ground.
the ground is she is residing at her parental place at Khodda.
Take notice.
And a FIR is lost.
When did you lodge the FIR?
Minute.
He's helpless but lodges FIRs against her in-laws. How many FIRs she has lodged?
Good FIR.
498A, 307.
323, 85, 296, 351, and section 3 of BNS.
Acha. New ye. I may not recollect.
Yes, it's a demand
So lodging an FIR, is there any case law on that wherever the wife lodges FIR against the husband, the matrimonial suit has to be transferred? Any case law? Supreme, because section 19, section 9 CPC, there's no provision. They're lodging of FIR. Any case law on that?
The convenience. Yes.
Which convenience?
That is. This is this.
That is your branch of practice. You practice in that. Which provision?
It's section 24.
Section 24. What is the language used? Convenience of the parties. That the High Court will read it. Convenience of one party at our so own sweet will. How can it be?
ଗୋଟେ କେସ୍ ଯେହେତୁ ଏଠି ଅଛି ଦିଟା ଗାଇଡ
ଗୋଟେ କେସ୍ ଆପଣ ଇନିସିଏଟ୍ କରୁଛନ୍ତି ନା ଆପଣ so the problem is that you have lost a criminal case. It's not a civil matter.
ଆଉ ଗୋଟେ
125 DV or something was section 18 maintenance is different thing.
sir
Because same court of jurisdiction they can try.
sir ଏବେ ଗୋଟେ ମୁଁ ପୁଣି ଡିଭୋର୍ସ ଟେ ଫାଇଲ କରିଛି ୟା ପରେ ପରେ ସେଇ ଖୋର୍ଦ୍ଧାରେ ସେଟା ଏରିଟ୍ ଆପ୍ଲିକେସନ ଫାଇଲ ପରେ ପରେ ମତେ ସେ ପରେ ଦେଇଛନ୍ତି ଡିଭୋର୍ସ କୋଟା ବି ପେଣ୍ଡିଂ ଅଛି ଖୋର୍ଦ୍ଧା
Who has filed now? You filed that affidavit.
ହଁ ମୁଁ ମେମୋ
ଆପଣଙ୍କର ଖୋର୍ଦ୍ଧାରେ ପେଣ୍ଡିଂ ଅଛି।
ହଁ
ତାଙ୍କର ଆଗ ଫାଇଲ କରିଥିଲେ
ନାଇଁ ତାଙ୍କର ସେକ୍ସନ 9 ଟା ଫାଇଲ କରିଥିଲେ
ସେକ୍ସନ 9 ରେଷ୍ଟିଟ୍ୟୁସନ ଟା ଫାଇଲ କରିଛନ୍ତି। ତ ସେଟା ଆପଣ affidavit ଦିଅନ୍ତୁ।
ଆଫିଡେଭିଟ କରିଦେବି ଆଜି ମେମୋରେ ଦେଇ ଦଉଛି
ଦେଇ ଦିଅନ୍ତୁ affidavit because she should be on oath when while stating ଆପଣ କାହିଁ ତାଙ୍କ ପାଇଁ ରେସ୍ପନ୍ସିବିଲିଟି ନେବେ ଲେଟର ଫାଇଲ affidavit। ବର୍ତ୍ତମାନ ଅସୁବିଧା କଣ ଅର୍ଜେନ୍ସି କଣ ଅଛି
ଅର୍ଜେନ୍ସି କଣ କି ସେଠି ମତେ ଡେଟ କୁ ହାଜର ହବାକୁ ପଡିବ
ହାଜର ମାନେ ଆପଣ ଯାଉନାହାନ୍ତି କି ସେଠି ଆପଣ ତ ସକାଳେ କୋଉଠି ଥିଲେ ସେ ଆଜି ତାଙ୍କ ପାଇଁ ହାଇକୋର୍ଟରେ ଆସିଛନ୍ତି ସକାଳେ କୋଉଠି ଥିଲେ
ସାର୍ ଗଭର୍ଣ୍ଣମେଣ୍ଟ କେସଟା ଥିଲା ଜଷ୍ଟିସ ଅନରେବଲ ଜଷ୍ଟିସ ବିପି ଶତପଥୀ
ଠିକ ଅଛି ସେଠି ଆପଣ ଆଡଜର୍ନମେଣ୍ଟ ନେବେ କେବେ ସେଟା affidavit କେବେ ଫାଇଲ କରିପାରିବେ
ସେଟା ମୁଁ ବୁଝିପାରିବି
ଆପଣ ରିଟ୍ ପିଟିସନ ଫାଇଲ କଲା ପରେ TRPC ଫାଇଲ କଲା ପରେ ଆପଣ ଗୋଟେ ସୁଟ ଫାଇଲ କରିଛନ୍ତି CP ବିଫୋର ଦ ଜଜ୍ ଫ୍ୟାମିଲି କୋର୍ଟ ଖୋର୍ଦ୍ଧା ଫର ଦ ଡିଜଲ୍ୟୁସନ ଅଫ ମ୍ୟାରେଜ ସେଇ ଯୋଉ ଜିନିଷଟା ସେଟା ଆପଣ affidavit କେବେ ଦେଇପାରିବେ
ସାର୍ ମୁଁ କାଲି ବି ଦେଇଦେବି
ଠିକ କାଲି ନେଇ ଆପଣ ଦିଅନ୍ତୁ
ମଣ୍ଡେ ଦେଇଦେବି
এটা সিম্পলি আডজর্ন করে দিন্তু উইক কমেন্সিং 16 আজ কে তারিখ 12 ঠিক আছে উইক কমেন্সিং 16 রে আসু ହେଲା ଆପଣ ଦିଅନ୍ତୁ ସେଇଟା
till then I will file application for adjournment
ସେଇଟା ଆପଣ ଆପ୍ଲିକେସନ ନ ଦେଇକି ଯଦି ତାଙ୍କୁ କହିବେ ଯେ ଆପଣ ଆଡଜର୍ନମେଣ୍ଟ କରନ୍ତୁ ହାଇକୋର୍ଟରେ ଅଛି ଓରାଲିସି କରିବେ ସେଥିରେ କଣ ଅଛି କି ମତେ ସେଥିରେ ପୁରାନ୍ତୁନି ଆଇ ୱିଲ୍ ନଟ୍ ପାର୍ଟି ଟୁ ଦୋଜ ଥିଙ୍ଗସ୍ ମୋର କାମ ହେଲା ମୁଁ ଜଜକୁ ଡିସ୍ପୋଜ କରନ୍ତୁ ବୁଝିପାରିଲେ କି I am also wearing a hat of an administrative judge. ଆଉ ଏଥିରେ ସବୁ ଇଣ୍ଟରଫିୟର କରିକି ଖାଲି କାମ ହେଲା ଏଠି ପେଣ୍ଡେନ୍ସି ବଢିବ ସେଠି ବି ପେଣ୍ଡେନ୍ସି ବଢିବ କେବେଠୁ ପେଣ୍ଡିଂ ଅଛି ସେ ସେକ୍ସନ 9
ସେ ଡେଟଟା ମୁଁ ଏବେ
ବୁଝିବେ ଆପଣ ଚେକ୍ କରନ୍ତୁ ୟେସ୍ ନେକ୍ସଟ
ସାର୍ 16 ତାରିଖରେ
ଉଇକ୍ କମେନ୍ସିଂ 16 ଏକ୍ସାକ୍ଟଲି 16 ଟଙ୍କା ପରେ will be adjusted.
Mature item 12.
Mr. Gautam Misra.
Well, Your Lordship.
Yes.
Your Lordship, I have a prayer herein for mediation, Your Lordship. If Your Lordship
mediation, you see, the problem is that will be a laughable order by a High Court. In a Section 13 application, that mediation is mandated. If the mediation is not, it is not sent to mediation, then you can come to High Court.
Yes.
But you are coming to High Court when the court has not, suppose has the court declined to send it to mediation?
No, Your Lordship.
Then you must understand that there is a statutory scheme of conciliation, cooling off period, 13B, 6 months, all those things are there. That is statutory mandate. Now High Court will invite everyone that you do mediation here. What is the scope?
Only if I'm
Where there is no such provision in the statute like Hindu Marriage Act of any mediation or conciliation, then it's fine. But is it that the court is not sending you for mediation?
No, Your Lordship.
What is the order? Because have you checked the order sheet of the trial court?
Yes, Your Lordship.
So what is the order sending you for mediation, conciliation?
Your Lordship, the
Because court counselors are there available for this purpose. High Court is appointing them. And High Court doesn't have any counselor because it doesn't have jurisdiction. You must understand that everything and anything cannot be the ground to interfere in a matter where the court of proper jurisdiction is taking up. Because that delays the proceeding, frustrates the proceeding. There are so many issues.
If Your Lordship can have an observation to that effect.
No, I can, but I should not look like a laughable judge. That he expects a district judge, family court judge, who is in the senior district judge, he will not send it for mediation. Suppose he is not sending, when you have a grievance, you come here, then I'll cite that provision that please send in or direct that you send it for mediation. But that is how the question.
Yes.
At times, I am also subtle. What was your response to the direction of the, if I ask you a direct question, then you will have no answer. That will consume more time. After the court has directed to go for counseling, what was your response? That's the direct question to you.
I do not have instructions with that.
That's the problem, sir. So this I hear you for half an hour and ask you this question, the entire 35 minutes is wasted. You take 30 minutes, take 2 minutes, 32 minutes, result is nil. So you have to obtain that instruction, whether it has been sent or not, whether it is, what was your role? I mean, what is this particular, the lady the wife in the marriage, how she has responded to the counseling.
Your Lordship, I have
On the
also
counseling, there is a professional counselor appointed by under the rules by the High Court. That scope is not available here.
I have also filed a petition for restitution of conjugal rights as well. That is to show my intent, Your Lordship.
Section 9 and 13 are to be taken up together.
Yes.
Section 9 is there. So any court where both, you have just heard your learned colleague, he says that she has filed, the husband has filed section 9, she has filed section 13, which I said that, he said that after filing of this TRPC that he has filed there.
Yes.
So that is to be on record. So if you have filed a section 9 for that court, then you pursue that.
Yes.
Section 9, High Court doesn't have power. That since 13 is pending, section 9 will be taken up by the High Court. Is it? No.
No,
You
Lordship.
will be tried in some court and you take your plea there. Maybe your defense also will be that I have already filed 13. No, the ground is, what was the 13 filed by the husband? What are the grounds taken?
Cruelty. Now they are alleging insanity. Unsoundness of mind. Now they are
You
after
discussed
comment.
this. What I have discussed you before this lunch break, you discussed aspects with your senior. You are conducting yourself the trial.
Your Lordship,
You are.
I just assist. He was just trying to analyze on another court rules. My lords, this is a matter where they have stayed together for 8 years, my lord.
No, you have to look at the first YouTube, it is available.
My lords.
What was discussed?
My lords, I was there in the other court. I have just seen your lordship asking the question whether we have to apply the provisions of the.
No, I didn't ask it. That is your perception.
My lords.
What I asked is completely different.
My lords.
I was trying to explain the part of the approach of the lawyer, not of the judge. So those questions, if you want to, again, I will not reiterate. You can see the video and come back.
It was just one fact.
I have asked very specific questions.
My lords.
So what are if I have understood the question, then you answer the first one. What was the first question?
The first question was with regard to res judicata, or there is a multiplicity of possibility of litigation. If the amendment is not allowed, what prevents him to file another case for
that is the smaller part of it. What is the larger issue?
should be the litigation being dragged on for a long time. That is what your lordship.
You will check.
The cruelty aspect of your lordship is
the principle of amendment. The question is if the principle of amendment or refusal, allowing amendment, applied to a suit, declaratory relief.
My lords.
Even have referred to District Relief Act and other declaratory reliefs and 13 applications.
Your lordship is right on that point.
No, I may be wrong. But the problem is that you are acting against the interest of your client. That was the question. That is the larger question.
Well, is there something your lordship
now the problem is, suppose now I say, what I said that I'll ask this also. Now I say that amendment is not allowed. The petitioner again will file this, taking the plea of insanity.
My lords.
Can the court, any court, or maybe High Court actually here now, or maybe the other court. The other court will say that res judicata. High Court will say that you cannot file a petition taking insanity as a ground. So that way the person who is seeking amendment and who is resisting amendment, it goes against the person who is resisting amendment. So that was the larger picture.
Well, it's one factual aspect your lordship will need to know to understand why we want a mediation to happen here.
No, then you have heard the mediation part.
Yes.
Just now I have heard. So please show me the order where the mediation was refused.
My lords, we'll file an additional affidavit.
No, not affidavit, order. I don't seek an affidavit. I want to see the order.
My lords,
what was the order on the which state counseling was direct?
My lords, it's not on the record. We'll bring it on the record by way of an additional affidavit.
No, not affidavit.
My lords.
Affidavits are not to be filed of the court's orders. You have to produce certified copies.
My lords,
the entire order sheet where it deals with conciliation, because I will record.
My lords,
that it is your submission that it has not been sent for conciliation.
No, my lords, it's been sent for conciliation. Lordship, one factual aspect is very critical to bring it to your lordship. There was an earlier proceeding of divorce, and only because of mediation, the parties decided to withdraw the divorce petition. The husband withdrew the divorce petition.
Anyway, that critical question has to be answered in terms of law.
My lords.
Which provision I can direct other than counseling mediation?
No, my lords, your lordship is absolutely right. That power.
No, I may be absolutely wrong, but you have to answer the question.
My lords.
Finding it whether I'm right or you are right is not the problem. I am absolutely wrong. Apart from the following the statutory procedure of counseling, other than that mediation, which court can direct? Under which provision? When the parties are not agreeing. Counseling is mandatory.
My lords.
So what is your response to counseling? That I have to see. The report is there.
We'll bring it on the record.
No, you must know that.
My lords.
What is your instruction?
My lords,
after a post-counseling, what was the response of the lady?
She wants to stay with the husband, my lords.
No, sir, that's not she is not the counselor. Counseling ku gala pare, tankar response kona whether the counseling succeeded or failed.
No, my lords, counseling failed.
Then you have to register the suit. The court cannot compel a husband not to file a suit.
Your lordship, may call this after a week. I'll speak to the client once, your lordship, and say.
You have to answer these questions. If you are saying that it has never sent for counseling, what is the order? The Learned Counsel for the petitioners. The Learned Counsel for the petitioner, you are Mr. Bishwal.
My lords.
Mr. Soumyajyoti Bishwal, Mr. G. Misra, and Mr. Soumyajyoti Bishwal. Appearance. Opposite party blank. The Learned Counsel for the petitioner was where hard at length. Mr. Misra, Learned Counsel submits that. No, submit sector likhuntu. Agar likhiyo the petitioner wife in the marriage, both of you take your seat. That takes time in dictating the order. It is submitted by the wife in the marriage is before this court challenging the order dated 2/2/2026 passed by the Learned Judge Family Court, Bhadrak, in seat number 149 of 2023. Para. By the said order, the petition filed by the petitioner husband in the marriage under Order 6, Rule 17 of CPC, arising out of CP number 149 of 2023, was allowed. Allowed, comma, thereby, comma, subject to payment of cost of rupees 500 within 7 days of passing of the order. The amended consolidated amended plaint was to be filed. The matter was posted to 5-3-2026. It is submitted by the Learned Counsel, Mr. Misra, that at the stage of co-stage, Mr. Misra?
After
Mr.
the
Misra, co-stage?
after the framing of issues, it has been
After
posted.
framing of the issues, the amendment was sought for, which has been allowed. Therefore, the court has committed error. Para. The amendment sought for has been reflected in the order dated 2026, which is reproduced herein. It is submitted by the Learned Counsel for the petitioner, page 38 dekhiye, up to be mentioned. In response thereto, the Learned Counsel for the petitioner was asked whether the ground of insanity is available to be taken in a Section 13 application, and if such ground is taken and amendment is not allowed in the present application, sentence out time. If the amendment is not allowed in the present application, present CP in the CP filed before the Learned Trial Court, whether the application of Section 13 (1) of the Hindu Marriage Act on the ground of insanity can be filed, or the present suit would be res judicata, subsequent application. In response thereto, the Learned Counsel for the petitioner, in response to the Learned Counsel for the petitioner has adjournment to address on the said issue. It is submitted by the Learned Counsel for the Mr. Misra as well as Mr. Bishwal. The petitioner wants mediation. On being asked under which provision this court can direct mediation, the procedure prescribed in Hindu Marriage Act as well as Family Courts Act for parties to be referred to counseling, basic, and have adjournment to address. This mention 24-26. The basic point for what has persuaded the Learned Trial Court, if I am negativing that, I must have good reasons. And actually, this is a fit case where, in the interest of the petitioner, the wife, she should be given the chance to defend her case. And if you want that, there will be several rounds apart from the court's time, when the litigant's time is also wasted. Maybe the lawyers will benefit. That's a different thing, but
posted the trial to
it is submitted by the Learned Counsel for the petitioner that the matter has been posted to
Lordship Tuesday next week.
17 on 17-3-2026. On the next date, the CP number so and so shall be adjourned to a upon kebe date deuchandi 24 jette dele haman pending ke jaldi the matter shall be posted to a date beyond 13/4/2026 subject to the convenience of the learned judge learned court in season of the matter. The matter shall be listed in the week commencing 6/4/2026 under heading fresh admission.
14.
I'm grateful, Your Lordship.
Yes, please. For a pass कितने करते अभी 5-6टा अच्छी है ठीक है प्लीज कैरी ऑन
Mature item 14.
non-appearance for the petitioner though the matter is called like a tinthor declared though the matter is called twice over once when it reached and thereafter upon the resumption of the proceeding of the court post lunch. As per the staff report, the petition has to be registered as CRL REV. Stop. Stamp report टा अपन डेट टा पके परिवे ना मु कहिबी 13 ना 14 13 तो जाइछ स्टाफ रिपोर्ट डेटेड 8/10/2021 the matter was presented before this court on 20/9/2021 it was placed before the Deputy Registrar Judicial Lojima by on 21/11/2025. Despite the pendency for more than 4 years, no steps have been taken by the learned counsel for the petitioner. The matter shall be listed. The matter shall be listed in the week on 18/3/2026 18/3/2026 for orders indicating that it shall be disposed of. Copy of this order as well as the next date of listing shall be intimated to the learned counsel for the petitioner by the registry. Yes, next.
Mature item 15.
Mr. S.N. Mahapatra for the petitioner, Mr. Sanjeev Budgata for the opposite party.
Well, take press notice and
the address has to be adequate.
Yeah.
The office note indicates that the unserved notice, Mr. Prem Kumar Bhanti. Appearance Lekhontu, Mr. Satyanarayan Mahapatra for the petitioner, Mr. Prem Kumar Mahanti for the OP number 4. एमती आगे लिखंतु 1 2 3 आगे लिखंतु Mr. Sanjeev Budgata for the OP number 1 2 and 3. Mr. Prem Kumar Mahanti, additional standing counsel for 4. The office note indicates that the notice issued to the OP number 5 has been returned unserved due to insufficient address. With postal remittance within court. That the insufficient address returned to sender empty courthouse. The learned counsel for the petitioner has for the time to find out the present correct address for taking notice afresh. Accordingly, the matter shall be prayer is allowed. Further 2 weeks time granted to find out the present correct address of the OP number 5 and take steps for issuance of notice. Unutilized copy be utilized. Yeah.
Entry order to call.
Para. Upon filing of the requisites, the registry shall do well to issue notice afresh to OP number 5. Interim order as passed earlier shall continue till the next date of hearing. केबे आसले हबो?
Your Lordship, मैं फिक्स हूँ.
नोटिस जीवो.
24
2 वीक देले ना 2 वीक आज होची केते 12 26 वीक कमेंसिंग 27 तारीख की देबे कि मेरे देबे 27 तारीख ठीक है. But don't take the notice in the same address because repeat filing of there's no point in filing again and yes. Yes, next.
Mature item 16.
এটা বিধি থরা কল করছেন
नहीं এটা তো পাশো
আসলে কেতে থরা কল করলেন এখন 3 থরা না 2 থরা
দ্বিতীয়
non appears for the petitioner though the matter is called twice over, once when it reached and thereafter upon resumption of the proceeding of the court post recess post lunch. The staff report dated 19/9/2022 indicates that RPFM may not lie. Quotation may not lie as the order assailed is not a family court order. Quotates. The petition was presented before this court on 7/9/2022. Stop. The staff report the staff report has not been complied with. Stop. It was placed before the learned Deputy Registrar Judicial, Lojima, for removal of defect oblique compliance of the staff report. And 3 weeks further time was granted for complying with the staff report. Though the matter is still pending, no steps have been taken. Stop. The matter shall be listed for orders on for 2/2026.
Okay.
Sorry, 3/2026, indicating that the matter shall be disposed of. Copy of this order as well as the next date of listing shall be intimated by the registry to the Lorded Counsel for the petitioner. Yes.
17.
Mrs. Aishwarya Das on behalf of Manoj Panigrahi for the petitioner. The petitioner husband in the marriage is before this court, challenging the order dated 12/7/2022 passed by the learned judge, Family Court, Kendrapada, in IA number 24 of 2020, arising out of देखो page 2 रे last matter page 2 ना appearance लिखिले कौन उकिल ना कौन लिखिले सूर्य राय तो राय क्या कुछ राय करे पर वचन करे पड़ो और आपण करछन मिसेस MSA डॉट दास वाले करन तो आपण तो मु ना पूरा कहले आपण कोन करछन ताको पावर नाही बोली मु डाकिली आपण तापर लिखिले IA number 24 of 2020 arising out of CP number 138 of 2020. The CP was filed by the not the CP was filed by the husband in the marriage under section 13 into bracket 1 of Hindu Marriage Act, seeking divorce. The IA was filed seeking maintenance pendent elite. Today, when the matter is taken up, memo of date is filed by the learned counsel for the petitioner, which states thus: memo is taken on record. Scanned copy be updated. Para. Accordingly, the petition stands disposed of. Copy of this order shall be forwarded to the learned judge, Family Court, Kendrapada, to be kept in the records of the CP number so and so, CP number 138 of 2020, and IA number 24 of 2020. Yes, next.
Such item 18.
Petitioner none, opposite party blank. None appears for the petitioner, though the matter is called twice over, once when it reached, and again upon resumption of the proceedings of the court post lunch. Matter was presented before this court on 1/11/2022. Several defects have been pointed as per the stamp report dated 5/11/2022. Thereafter, the matter was listed for removal of defects before the learned deputy registrar into bracket judicial, Logima. Stop. The learned registrar judicial directed the matter to be listed before the roster bench. Till date, the defects have not been removed. The matter shall be listed for orders on 19/3/2026, indicating that the matter is to be disposed of. Copy of this order along with the next date of listing shall be intimated to the learned counsel for the petitioner, shall be intimated by the registry to the learned counsel for the petitioner. Yes, next.
Passover item 19.
My lord, 19, I am the petitioner, my lord. My lord, the one miscase has been filed. Hearing number
22 fresh admission order se kahi aschi to hearing hoba katha entry order kon semti vacation hue bench change hi gale in the service matter or selection matter, how the entry order will be vacated without hearing the other side.
No, my lords, I have filed on because my lords, honorable division bench on the very similar issue has said that the advertisement or the rules are not detrimental or are not violative of any fundamental right.
Sir, you are arguing against yourself. This is what I was expecting, that if you are arguing on merits, how can I vacate the interim order? I will say that yes, the court is allowed or dismissed. You are just arguing on merits also. That in view of the judgment of the division bench, so and so finding has been given. So for that reason, how can you vacate the interim order which was passed after hearing all? And when the interim order was vacated?
There are two dates, my lord.
You are appearing in which matter? First or second?
My lord, I am appearing in
both.
30062 first.
First one, yes. Yes, Mr.
So when the second connected case is concerned, my lord, I think, my lord,
My lord, second
it is for withdrawal.
Correct.
Second sub item
It's likely what you are endorsing his view that after the division bench judgment, so they are seeking for withdrawal.
And my
I
lord,
don't know, I cannot say, but most likely.
no, both the cases, my lord, the prayers are identical. The petitioner now decided to withdraw the second case. The petitioners in the second case. Now, so far the first case is concerned, my lord. That is what now it has been presented for lordship. In a division bench, my lord, your lordship had also written that on. Yes, that when the rule was actually challenged, it was paid for the division bench along with this the same advertisement, and the lordship did not interfere with the same. So I
judgment जो record तक आने पड़े होता है reference में, because I can't take up a division bench matter. Dispose of.
Well, the order is paid.
So record तक call. Yes, Mr. Patnaik.
मालक I would data प्रभु सेटा आसो
ଆପଣ ସେଦିନ ବି କରିବେନି ଆପଣ ତ ଏବେ ମ୍ୟାଟ୍ରିମୋନିଆଲ କୁ ପଳେଇ କଣ୍ଟ୍ରାକ୍ଟର କୁଆଡେ ଗଲେ ଆପଣଙ୍କର
ସେ କେସ୍
ସୁଡା କଣ ହେଲା
ସେ ସବୁ ସରିଗଲା
ସରିଗଲା ଇଏ ଥରେ ଏଟିଓ ଇଏ ବି ତ ସରିଗଲାଣି ଆପଣ ବି ସାରନ୍ତୁ now after seeing the judgment I realized that
I am appealing on behalf of opposite party number 5 in the past matter manner. The counter affidavit has already been filed as per my record manner. It has not been taken into record of the suggestions.
It's a Das, Saurav Das.
Yes, ma'am.
So for the day, we can post the matter to another day and record your submission that this matter stands covered by the decision of this division bench.
Yes.
Correct?
Yes.
So Mr. Patnaik will be happy. Now, what about the second matter? You want to withdraw it?
second matter ଟା withdraw
ଏଇଟା withdraw
ନାଇଁ ସେ ପାଇଗଲା ସେ ସବ ଆଇଟମ ଟା ସେ ପାଇଗଲାଣି ଚାକିରି ସବସିକ୍ୱେଣ୍ଟ ଆଡଭର୍ଟାଇଜମେଣ୍ଟରେ ସେ ସିଲେକ୍ଟ ହେଲା
ତ ଯୋଉଟା division bench has noted subsequent advertisements, many of them have got jobs. That has been noted because we called for a report that how many posts are remaining vacant. How many are getting this are not by the case, of course, not by the merit पाइबे, criminal पाइबे. ना copy भी करी पाइले ना कौन. That is beside the issue. तो जोटा कहूँचोनी there is no relevance merit पाइले कि नहीं. But it was also noted that subsequently some of them have applied and got through. I think that paragraph will be there.
She has no grievance to
the PTGIs who have already got selected through the selection process and have availed the benefit of best relaxation as per advertisement and have joined as ATO shall continue in their respective posts. So that was also a concern that if any sweep or directs any other way, then they may be impacted. It is there. Upon set up the upper appeal could not please. You are completely blank. You are not there. ବେଶୀ ବ୍ୟାଚ୍ ରେ କିଛି ନଥିଲା ବୋଧେ ମିଷ୍ଟର ପଟ୍ଟନାୟକ
ନହେଲେ
ଆପଣ କଣ ମାନେ ମ୍ୟାଟ୍ରିମୋନିଆଲ ମ୍ୟାଟର ନା ସର୍ଭିସ ମ୍ୟାଟର କୋଉଟା କରୁଛନ୍ତି ଆଜି
ସବୁ ମିଶିକି
ଏଇଟା କଣ ମ୍ୟାଟ୍ରିମୋନିଆଲ ନା ସର୍ଭିସ
ଏଟା ସର୍ଭିସ
ଆପଣ ୟୁ ଆର୍ ଲୁକିଂ ଲାଇକ୍ ଆଜି ଫିୟର ମାନେ କମ୍ପ୍ଲିଟଲି ବ୍ଲାଙ୍କ ମୁଁ ଯାହା ବି କହୁଛି ଆପଣ ମତେ କାବାଇ କରୁନଉଛନ୍ତି
ସେ ଅଲରେଡି ଗଟ୍
yes so
subsequent advertisement he has appeared she has appeared
submitted Mr. Achitananda Patnaik for the petitioner that WPC 3006/2022 ହେଲା Mr. Prem Kumar Mahanti, Additional Standing Counsel for UP number 1, 2 and 4. Hello. Mr. Surya Narayan Patnaik, Standing Counsel.
Yes.
for OP number 3. Mr. ଆପଣଙ୍କ ନାଁ ନାହିଁ ଏଥିରେ?
Narayana Patnaik, Senior Panel Counsel for OP number 5, Union of India.
Then why Mr. Das is appearing? You should be Patnaik also. Achyutananda Patnaik, Surya Narayan Patnaik, Darpan Narayan Patnaik.
Today I have assigned with the case.
No, he has one Patnaik also as his associate. On लिख ले तब Darpan Narayan Patnaik for OP number 5. Pro forma OP 5. IE 34286 टा आपण फेल करचंदी. So Das.
I have filed IA number 8440 intervention, and after that subsequent IA is for vacation. Yes.
Intervention has been allowed.
Yes, my lords. Intervention has been allowed for consolidated.
Order dated?
My lords, order dated 7/11/2024.
Because the problem is somehow the cost title has not been amended. So I am unable to figure it out.
My lords, cost title.
You have been added as a opposite party.
Opposite party number 6 to 11. It was allowed. But cost title was
Patnaik is muted. Main Achyutananda Patnaik is now muted. He doesn't responding to anything actually.
I have not filed the intervention.
Sir, it has been allowed, sir. Who has filed? So you have to file file an amended cost title. Now I see a cost title where it contains only 5 OPs.
My lord, the copy has not been solved. Intervention.
Allow here upon serve over.
Copy receipt করছেন
তাহলে এইটা আয়ে 3438 এর মধ্যে
File it.
I think it will abide by the division bench more so when I have myself party to that. Nothing survives actually.
Copy of the miscase IA number 34280 maybe.
ଦେଖୁନାହାନ୍ତି
ସେଟା ଦେଇନା.
You show him the order. He may be in doubt, but ଆପଣ the order ଟା ଦେଖେଇ ଦିଅନ୍ତୁ.
ସେଇଟା vacation of state আমি ଦେଇ ଦଉଛି କିନ୍ତୁ
ସେଟା
Intervention କୋଉଥିରେ allow ହେଲା କହୁଛନ୍ତି Mr. Das?
7/11/24 এইটা পড়বে
ସେଇଟା ଦେଇ এইটা কিন্তু ଦେଇନା.
এইটা vacation of state আমি ଦେଇ ଦଉଛି ଦେଖିଲେ payment ହୁଏ ନଥିବ କିନ୍ତୁ এইটা ସାର୍ ଆଗରୁ ଦେଇଛି ଆପଣ
ଆପଣ ନେଇକି ଲାଭ କଣ ଆପଣ ଆସିବେ କ୍ଲାଏଣ୍ଟ ଆସିବେ ଆଉ ଆସିବେ କାଇଁ ନଉଛନ୍ତି ଛୋଡା
ଫୋନ
କରୁଛନ୍ତି. Your account is linked to the phone. That is the crucial part, sir. Yes. The Learned Counsel, Mr. Saurabh Das, it is likhibe IE habo 3428 of 2026. ठीक. The Learned Counsel, Mr. Saurabh Das, submits that pursuant to the order passed by the coordinate bench in IA number 84440 of 2024, the intervention application was allowed. So, by the said order, the intending interveners were arrayed as OP number 6 to 11. The coordinate bench had directed for filing of the consolidated cost title within 7 days. So, as it appears, the consolidated cost title has not been filed. The same shall be filed within 7 days. ଆପଣ ଗଲାଣି 2 ବର୍ଷ ହେଇଗଲାଣି ଆଜ୍ଞା. 1.5 ବର୍ଷ ହେଇଗଲାଣି.
ଫାଇଲ କରିଦେ 7 days.
Consolidated ଆପଣ ନହେଲେ ସେଟା ହେଲ୍ପ କରନ୍ତୁ ତାଙ୍କୁ ସେ କରିବେନି. Consolidated cost title filed within 7 working days. Para. तापर लिखन्तु the Learned Counsel for the petitioner, the Learned Counsel for the opposite parties was heard along with the Learned Counsel for the petitioner, the Learned Counsel, Additional Standing Counsel, the Learned Senior Panel Counsel.
Senior Panel.
Senior Panel. And and the Learned Counsel for the Staff Selection Commission. It is submitted by the Learned Counsel, Mr. Das, for the opposite parties 6 to 11 that the interim order has to be vacated in view of the judgment rendered by the division bench.
But the issue is different, my lord.
For the intervention, we
intervention.
My judgment dated 31/10/2025. ଆପଣ ଏଠି ଆପଏଣ୍ଟମେଣ୍ଟ ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି ତ?
ହଁ ଆଜ୍ଞା ସିଏ ଅଲଗା ବୋଲି ସିଏ ଡିଭିଜନ ବେଞ୍ଚ ଗଲା ହେରି।
No, my lords, the only difference is in the division bench, the rules and the advertisement were challenged. And here only the advertisement is challenged.
Pattanaik have some difficulty forgetting. I can tell you the sequence also.
My lord,
ସେଟା ଅଲଗା ପାଇଁ ଯାଇନି। ଆପଣଙ୍କର ଏଣ୍ଟ୍ରି ମଡେଲ
ସେମାନେ
ବୁଝିପାରିବେ। This is a single bench matter. But since in those batch of matters, after the entry models were passed, it was modified. The rule was challenged. Then it was posted before the division bench. So that plea is not that. So it is not a different plea. This is a single bench matter. But now suppose you are challenging because now this challenge to rule will no more survive also.
My lord, the issue in writ petition passed in division bench.
Identical.
In the issue of
Identical. The issue before the division bench as well as this bench, the division bench was a single bench matter. I hope you understand. Because the virus was challenged, it was transferred to division bench. So it's the same set of application. And that is how the second matter, as you are first saying, that was also taken care of. The ordering portion of the division bench order takes care of all the, all the aspects. Which now covers the field. Judgment लिखिले, judgment dated 31/10/2025, passed in WPC number 29894 of 2022. It is further submitted that the issues involved in the ଆପଣ କଣ ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି? Advertisement dated 2/11.
CITS qualification is mandatory for recruitment of the post of the active, my lord.
Just read that. That exactly is the point answered. Or लिखिले? Is already answered by the judgment of the division bench dated 31/10/2025 in WPC number 29894 of 2022. It is further submitted that the writ application that was recited by the division bench is identical as far as the prayer and the facts are concerned. The only difference being the virus of the statute was there in the said application. Therefore, after the virus of the statute was challenged by amending the said writ application, for which the matter was taken up by the division bench as for the determination. The Lord Counsel for the petitioner has adjournment to go through the said judgment. Go through the judgment as noted above. केबे चाहते मिस्टर पटनायक?
My lord, what मासे
कौन करिए बस रखिगी?
But in this case, my lord, with respect to this advertisement of 2022, now, my lord, all the cases have been disposed of. Here, my lord, this case is pending along with an interim order. Because, my lord, there is an interim order. Other candidates, my lord, who are now aspiring to get that particular
that has been answered in the judgment also.
Yes,
the division bench has taken note of that also.
That is the reason,
but the problem is that Mr. Patnaik is now looking at me as if he is arguing some other. Yes. There is no point, Mr. Then they will go to Supreme Court now. You know what they will argue? That same judge sitting in single bench is not looking at the division bench order. Listing the week commencing 23/4. Yes, sorry, 23/4 को शेटा 3 मास. In the week commencing 30 list for orders. The matter shall be listed for orders.
Second.
The field.
My lord, this case ta
ଆପଣ ଗୋଟେ ଯେମିତି ଲେଖିଛନ୍ତି accused. Matrimonial matter accused କଣ? କଣ manufacture କରୁଛନ୍ତି? ସବୁ ଜାଗାରେ accused ଲେଖିଛନ୍ତି.
ସେଦିନ କପି ଅଫ୍ ଦି
ଯିଏ ପଢିବ ହଠାତ୍ ଅର୍ଡର ମୁଁ ପ୍ରୋବ୍ଲେମ କଣ ଆକ୍ୟୁଜ କଣ ମୁଁ ଡାକିଲି ମୁଁ ବି ବୋଧେ କଣ ମୋର ପ୍ରୋବ୍ଲେମ ହେଲାନି
ସବୁ ଆଇଟମ ଟା ୱିଡ୍ର
କିନ୍ତୁ ଆପଣ ଆକ୍ଚୁଆଲି ସେ ଜଜମେଣ୍ଟ ଟା ପଢନ୍ତୁ
ନାଇଁ
ଆପଣ ଆକ୍ଚୁଆଲି 2/11/2022 ରେ ସେଟା ସେ ମାନେ ଏଣ୍ଟ୍ରି ମଡେଲ ବି ଭେକେଟ୍ ସିଙ୍ଗଲ ପେଜ କରିଦେଇଛନ୍ତି ଅଲିୟର ମଡିଫାଇ ହେଇଛି
ସବୁ ଆଇଟମ ର ଗ୍ରିଭାନ୍ସ
ଆପଣ ଏବେ ଯେତେ ମାନେ ମ୍ୟାଟ୍ରିମୋନିଆଲ ମ୍ୟାଟର ଗୁଡା କରିଲେ ବି ହବନି ସବୁ ଆଇଟମ ଟା ତ ୱିଡ୍ର କରିବେ ମୁଁ ଡାକିନି ସେ ମତେ ଇଣ୍ଟରଭ୍ୟୁ କରି ସେ ମତେ ପଚାରୁଛନ୍ତି ଆଉ ଗୋଟେ କ୍ଲାରିଫିକେସନ ଚାହୁଁଛନ୍ତି ତ ନାଉ ଦ ମ୍ୟାଟର କଭର୍ସ ଦ ଫିଲ୍ଡ ଯୋଉଟା ସେଟା ସେ ପଚାରୁଥିଲେ ସୋ ଆଇ ହାଭ୍ ନଟ୍ ଡିକ୍ଟେଟେଡ୍ WPC 15659 of 2024 Mr. Achyutananda Patnaik for the petitioner ଏଥିରେ ଅଜୟ ରାୟ ନା ଆପଣ ଆଜି ଆସିଗଲେ ଅଜୟ ରାୟ ଆସିଗଲେ ଠିକ ଅଛି Mr. Prem Kumar Mahanti for the OP number 1 and 2. Mr. Suryanarayan Patnaik, standing counsel for OP3. Prem Kumar Mahanti for 1, 2 and 4, Chief Secretary Ocean. Mr. Ajay Kumar Rai, Senior Panel Counsel for OP5. IA 19581 of 2025. On the 3 would IA file kari I think that will work for you. You will call the petitioner to file a IA. Mr. Rai has understood it, so you ask him. The IA has been filed with the following prayer. They submitted is submitted by the learned counsel for the state as well as the learned standing counsel for the learned standing counsel for the OP number 3 and the learned senior panel counsel that the matter no more remains in res integra as in view of the judgment dated 31/10/2025 passed in WPC number 29894 of 2022. In view of the said judgment, as well as the prayer made in the IA, the writ petition is disposed of. The interim orders, if any, can vacate it. Yes. Yes. Yes, Mr. Patnaik, disposed of.
Well.
Item detailed account.
Item 36.
Yes.
May it please your lordship. I'm for the opposite party, your lordship. Your lordship, honorable court had directed to file an additional affidavit, your lordship. Party could not be present because she is suffering from conjunctivitis. So 1 week time may be allowed. I will file in the next date. Your lordship is not audible. Sorry, your lordship.
That is the best thing to happen. The less I am heard is better.
Apologies.
They are saying that it is happening to every court. So at times you are freezing. Now I am not audible. So who is scared of getting conjunctivitis? The council, because the party herself has.
Party herself, your lordship.
So you filed the affidavit anyway. Yes, because he is appearing in person. Yes. Any progress could be made regarding admission.
Sir, I just want to submit.
Yes.
Sir, this court had earlier directed both parties to arrive at convergence regarding the admission of our son. In the previous hearing, the opposite party had submitted that they intend to secure admission in KIT International School, which I support. And despite my repeated attempts through emails, letters, phone calls, and personal visit to their home, requesting discussion and convergence, I was not involved in any process related to KIT. I have tried my level best to communicate with the opposite party, but no success on that. I therefore request this honorable court to kindly ensure that the admission process, if it is in KIT, is completed and in accordance.
That can be done. Mr. Patnaik, I said last time I told you that the court cannot confer lock on the student.
Again.
I mean the child, small kid.
Sir.
The reason being, I had experience of directing sitting within a division bench 3-4 years back. I have an experience of directing the student getting admission in KIT. So court doesn't have any difficulty.
Okay.
But why it should happen? Why the mother and the mother and the father will not go to school?
Sir,
in our days, of course, we were not accompanied by our parents to go to school. We used to go to the school, take admission. Maybe some free time, the parent, father or mother, they will talk to the teacher. That child will go and you get him admitted. Even documents and all those things we have to carry, or the teacher himself will manage. So those days have changed. So there is no difficulty for directing, but why that order should be passed? Because you see, you must understand.
Yes.
This will remain forever.
I totally
and the
understand.
memory of getting the child admitted still remains indelible.
Yes.
You can ask your parents, they will remember the first day in your school.
Yes, sir.
So that's the point. That in fact, I did not say elaborated that why the court will interfere.
No. Wherever.
So yes, Ms. Das, can you please hear the other side also, because you have some difficulty in VC.
Now it is audible, Your Lordship.
So it is a very genuine thing that you complete the admission procedure in KIT International.
Yes, Your Lordship, definitely.
Yes.
Sir, I have one more prayer.
Yes.
It is well known that the child is suffering from ADHD. So in the meantime, I am just requesting this honorable court's indulgence that I should be allowed to take him outside to play in the park and return. In the previous
but you are already.
Sir, garage re khali dekha hoy parchi, so it is very difficult to keep the child.
School jao.
Jao. Mu khali coach sir, weekend to visitation hoji.
One thing I must again and again I have been telling you, Mr. Patnaik.
Again.
Your chemistry is not lost. Both of you are still, you should have some chemistry. You seem to be having chemistry. So maybe the child will be the medium for you to interact and all these things. So let us be patient. So yes, any immediate response, I am not saying.
Your Lordship, regarding the visitation right of the child, father has all the rights to visit, and problem is the child is hyperactive, Your Lordship. That is why taking him to the park or any
Child is hyperactive. The father can take care of child. Hyperactive childs also.
Yes.
How do you know that I am not hyperactive? How do I know that you are not hyperactive? So it is not a condition. I think Mr. Sethi also clarified that. He intervened that it is nothing. No, it is not a problem.
Yes, Your Lordship.
Your Lordship, any kind of sports activity?
Yes. That is the reason that he should. The energy he is generating, it should be directed towards a particular sports or anything. So why you are not? If you can take the child, you see, you must not think. You have heard the additional standing counsel.
Yes, Your Lordship.
Suppose now you have all the time to keep the child in your home, or you are allowing only at the garage.
No, Your Lordship, child is involved in extracurricular.
Before I complete the sentence, don't interject because I can't complete.
Yes, Your Lordship.
The necessity is that he must go out.
Yes.
And in a secured, maybe he should be taken care of, but he should be watched and he should participate in some outdoor activities. That will help the child also. And if you say that the father will definitely take care. Because over apprehensive or being anxious. Just 1 second. Rules 19. 19 ରେ ଆପଣ ଡିକ୍ଟେସନ ନେଉଛନ୍ତି? ଓକେ ସାର୍ ଗୋଟେ ଲାଇନ୍ ଆଡ୍ କରିଦେବେ। 19 ର ଫାର୍ଷ୍ଟ ଆଇଟମ୍ 30062. Copy of the judgment of the division bench produced before this court shall be kept on record. The 19 ର 30062 ରେ ଲଗେଇଦେବେ। So that is a very fair enough proposal, and don't be over apprehensive and over possessive. Parenting should be common activity for both the mother and the fathers.
Yes, sir.
This court cannot say that mother is more caring or father is more caring. Similarly, I cannot say that the mother is irresponsible, father is irresponsible. Please appreciate that. You have to pursue it.
Yes, sir.
And by approaching before the court, now the father has grown gray hairs. Earlier, your hairs were not gray; they are looking black.
Right, color.
Okay. So you should have some counsel also, wearing the gray hairs. Pursue it. Actually, this is a case where absolutely there is no difference. There is some issues and all that. Yes. Yes, anything else, Mr. Patnaik? Those two aspects.
The last part is that I should be given the school access, that I do not have any information when the child was studying in.
I will observe something regarding that. Purposefully, I am not making the order any kind of adversarial. I mean, I am not recording, I am avoiding to record anything as far as allegations, that not exactly allegations, anything that he is not doing this, she is not doing this, that kind of thing, but I will observe definitely. You take your seat, I'll dictate that. Roshan Patnaik in person. Miss Suchismita Das for the opposite party. Ms. Das Learned Counsel being present at the virtual court, High Court of Orissa, virtual court, High Court of Orissa, Khurda at Bhubaneswar, addresses arguments. The matter was marked to be taken up at 2 p.m. Due to continuation of the other passed over matters, the matter was taken up at 3:15 p.m. The petitioner is present in person and heard, and so also the learned is asked of the opposite party. It is submitted by the learned counsel for the opposite party, referring to the order dated. Ms. Das, you are referring to which order?
Your Lordship, order dated 29/1, Your Lordship.
Order dated 29/1/2026.
Yes, Your Lordship.
As well as the 5/2/2026 and the subsequent order dated 26/2/2026 submits that opposite party was to file an affidavit which she has not been able to, as she is suffering from conjunctivitis. At this stage, filing of affidavit by the opposite party in response to any of the submissions and affidavits filed by the petitioner is not that important, as the central issue is regarding getting the child admitted in a school. Stop. Para. It is submitted by the learned counsel. It is submitted by the petitioner appearing in person, who is father of the child, that he agrees the child to be admitted to the KIT International School. KIT International apna koichhanti na?
Yes, Your Lordship.
KIT International reference code thila puti. KIT International School, as was recorded earlier by this court at paragraph 17 of the order dated 26/2/2026. Stop. It is submitted by the petitioner appearing in person that he is not involved in the process of school admission, and for no reason, and there is no reason why he should not be involved. it is submitted that the petitioner's father has visitation rights for the child. However, he has not been able to take the child to play. And he is mostly confined to a place in the premises of the residence of the mother of the child. So, it is in response the learned counsel for the opposite party mother submits that the child having ADHD requires to be constantly monitored, and it may not be safe to have the child play in open. In considered view of this court, the concern expressed by the mother, as stated by the learned counsel, is appropriate. Stop, however, comma. It cannot be presumed or however, it cannot be assumed that the father will not take care of the child. It shall also be open for the opposite party mother to remain present if the child plays in the open, particularly in any place where there is ample space for the child and other playing equipments. The child should be taken to an open space to play, for which the petitioner and opposite party are directed to agree. It would be at their option to remain present. It would be at their option for both of them to remain present. However, at least one should be present to take care of the child constantly, along with any other person apart from them. The opposite party is also directed to complete the admission process as has been stated by her and noted in the earlier orders for admission to KIT International School, which has agreed to provide the best of the facility considering the hyperactivity of the child. Is that when you can complete the admission process?
Your Lordship, I will take instruction from the party. I'm sure I have no instruction.
The whole problem is that again you are back to square one. You are not present perhaps.
Yes, Your
This was
Lordship.
elaborated, widely argued by your learned colleague, Mr. Om Swarup. Now you have forgotten what was argued.
I have read the order.
After a deliberation of half an hour, I have to tell you that you have stated regarding so many things in KIT admission. Even you have stated that the KIT people are being threatened now, which is part of record. Upon a instruction nebi. Count instruction nebi. Material na ne oral na material jete neba katha niyantu, but oral kon nebe.
Your Lordship, regarding the admission.
Regarding the admission, you have lost the track actually. It is you who have suggested that you see the child will take admission in KIT International. I hope you understand what you are saying. So on the third day of hearing, you are saying that I will take instruction after you have initiated the whole process. At this stage, on being asked, the learned counsel for the opposite party submits that she will take instruction regarding the admission of the child, which is rather unusual and strange. That after the opposite party has herself suggested for admitting the child to the KIT International School, and the court has proceeded on that basis. I don't understand, sir. You are just wasting valuable time. He was suggesting some other school. You suggested for KIT International. Court directed for KIT International. And on the, after about almost I think it started in January. Now in March you are saying that I will take instruction. Then Ms. Das, this is a fit case which I have been thinking that the child should be handed over to the child helpline.
No, Your Lordship, mother is fit guardian to this case, but problem is
she has demonstrated by her conduct, vacillating conduct, that she doesn't know what she is doing.
She is very much
and unnecessarily the time is wasted. How can conjunctivitis in the ground for filing an affidavit? Do I state many things in a lighter vein? What is there for the filing of affidavit also today? There is nothing. You must have marked the opening statement that there is nothing for filing of affidavit. It is only ploy to take an adjournment. So you take that instruction. I'll hand over the child to the child helpline.
So Your Lordship, mother can take, even father have equal rights. We have no objection regarding it.
Don't give a speech. You are answering whether I'll record, because it is also recorded.
Apology.
You have said that you get the child admitted in KIT International, which has the best facility. You are not reading even the orders also. Today, when you are asked that when you complete the process, you are saying I'll take instruction. Mother's right, who is discussing now? You are giving a speech on that. The admission process shall be completed. In the KIT, it is directed that the admission the opposite party shall, or for admission, I will hand over the custody to the child helpline. What is that called? That child welfare committee.
Your Lordship will comply with the admission process. As per the Honorable Court directs, we will comply, Your Lordship.
अरे आपनकर सुबुनी कथा आपनकर उल्टा कथा कहलेनी आपण किसी कंप्लाई करू नांती.
We will definitely comply with the orders.
Pick something which makes sense. You are completely out of track. Completely out of track. Being a lawyer, you should do some justice to your profession. Don't go on saying something which does not make any sense. You said that the child will get admitted to KIT. Now that when it is that the father is asked that he will get admitted to KIT, now you say that I will obtain instruction. Then you are saying that I will comply. Call it. As she has stated, for getting the child admitted to the KIT International School, shall take all the steps for getting the child admitted to KIT International School. Bracket लिखिए से order उड़ा quote करिए पड़ियो से कोटी को इतने से recording है इधर it has been recorded also. The petitioner husband is also directed to cooperate in getting the child admitted. In each step of admission of the child to the school, both the petitioner father as well as the father and the mother shall be involved. None of the parties shall raise any plea regarding non-availability, difficulty, health issues, as far as admission of the child to the school is concerned. On approaching the school authority shall also extend all necessary assistance for admitting the child to the school. Yes, you talk. I'm passing it over. You take specific instruction by what time the child is getting admitted, or this is a fit case where because of the incompetent mother, the child has to be transferred to the child welfare committee. You take instruction. I'm passing it over. So that at least that much that date I will accommodate you.
Yes, Your Lordship. Definitely.
So don't go away from the court. You leave the court. I mean virtual court, but again you come back and tell the date by which date the child is getting admitted.
Yes, Your Lordship.
Well, actually, you see, this is a classic case where you have drawn sympathy from the court. The court has insisted, I mean, prevailed upon the father that the mother will decide the place, and she has decided the KIT International School. Now, after 2 months, now you say that I will take instruction. And mother's right for over the child, you are telling the court. Passed over. Order the admission process shall be completed by dash date. The date is a coin. Yes. Please passed over. You wait for some time. Yes.
Yes, sir.
Next. Dakun serial Dakun.
May I please, Your Lordship. As per the instruction, we have entered appearance for the opposite party mother-in-law. In this case,
Ms. Kaberi Mahanti for the petitioner.
Petitioner. I have.
You are Mr. Ashok Behra. You are associate of Ashok Behra.
Yes, Your Lordship.
Your name, sir?
J. Swai.
Mr. J. Swai for the opposite party. Yes.
Oh, this is a transfer petition, my lord. And I have filed 2 IA. One is amendment and another is modification of order.
The same as not solved.
Ms. Mahanti, solve copies. Let us not spend our time like this. Solve copies and let it come on another day. आइए दीटा कोटा नंबर कहले
116 2025
117 114 काହାର फिर
116 117
114 टा
14 नहीं आज्ञा 116
बंद लिस्ट देखिबेनी सब कथारे कहबे नाही आज्ञा
14 टा आज्ञा मिसकेस फाइल आगरो हेइथिला
कोन पैसा टा करछन स्टे पाई
आज्ञा
स्टे हेछि डिस्पोज ऑफ हेछि ना पेंडिंग अछि
पेंडिंग अछि
it is submitted by the learned counsel for the opposite party that copies of the IA number 116 and 117 of 2025 be served. Aji debe na kebe
Aji ebe.
Copy of the IA shall be served according to stop. The learned counsel for the petitioner shall serve copies of the IAs within 2 working days. List for orders in the week commencing.
Next
week हे परियो सेमिति कोन हुए 6-4 करंतुनी ताकू ता पूर्वुर केबे हे परियो आपनकर बर्तन आइले कोन कंसीडरेशन कोन फाइल करछन्ती कोन पई
116 टा आज्ञा अमेंडमेंट करछ ए मॉडिफिकेशन ऑफ हाई कोर्ट ऑर्डर आज्ञा
हाई कोर्ट स्टे हेनी बोली कहले आपण
सेटा आज्ञा एसडीजीएम जाके कोर्ट जागा रे फैमिली कोर्ट हे जाइछ टाइप मिस्टेक सर्टिफाइड कॉपी रे टाइप मिस्टेक हे जाइछ
जो डीबी केस टा ट्रांसफर मागी चंदी पूरी की टू एसडीजीएम जाजपुर टू
एटा कोन डिस्पोज ऑफ केस
नहीं
पेंडिंग केस
इश्यू नोटिस हेइतिला
इश्यू नोटिस में लिखा जाइछि भूल रे
नहीं से जो पिटिशन टा ड्राफ्ट करछंदी सेते जो एसडीजीएम
सेटा अमेंड करिवे जे
हां सेटा अमेंडमेंट
मॉडिफिकेशन पूछोंती मु अमेंडमेंट बुझियोली आपण
मॉडिफिकेशन सर्टिफाइड कॉपी रे अछि बोली
सर्टिफाइड कॉपी एटै परियो सेठी हो आपण सेठी अप्लाई करिवे नो कोर्ट कैन टच ए सर्टिफाइड कॉपी ऑफ इश्यूड बाय ए पर्टिकुलर कोर्ट ऑफ जुरिसडिक्शन
पिटिशन कॉपी रे आगे मोर
अरे आपण मिक्सअप करंतुनी मैडम काइंडली लिसन आपण इम्पेशेंट हेले प्रॉब्लम हबो आपण गोटे अमेंडमेंट फाइल करछन्ती अमेंडमेंट करिवे
ଆଜ୍ଞା
आपण मॉडिफिकेशन ऑफ ऑर्डर जो लिखिछन्ती एप्लीकेशन
ସେଇଟା
को ऑर्डर टा मॉडिफाई हबो
ସେଇଟା
की पास करछन्ती से ऑर्डर टा आपण को पचारिली आपण जे प्रथमे कहले जे किछि नाही 114 स्टे ऑर्डर सेते पचारते
ସେଇ ସାର୍ କରୁଛନ୍ତି ଏସକେ ଜଷ୍ଟିସ ଏସକେ ମିଶ୍ର
कोन टा कोटा मॉडिफाई हबो को ऑर्डर टा देखंतु
114 कहतली
सेटा ଟିକେ हेल्प करंतु सेठी सेपटे तांको स्क्रीन रे काढी दोनांती
114 कहतली
जस्ट काइंडली यूज दिस पेपरलेस आपण पई सेटा तो रखा है
देखो एठी
काइंडली सी देयर कोटा आपण चाहउछन्ती मॉडिफिकेशन
ऑर्डर टा देखि नियंतु
modification ହେଲା ଆଜ୍ଞା my prayer order dated 3/12/2025 SDGM पुरी in place of family judge court पुरी सेटा family judge न है कि SDGM हबो
सेटा को पैराग्राफ रे
prayer 116
फिर अपन पुष्टा उठे देले 3/12/25 ऑर्डर मॉडिफिकेशन चाहउछन्ती
आज्ञा
लुक एट द ऑर्डर को पैराग्राफ 116 कहलेनी तक पैराग्राफ 116 किमती हबो
para 6
हां कोन कोडा अमेंडमेंट
पेज 116 पेज नंबर 2 रो 1 2 in para 6 fourth line of certified
oh
copy
madam please be you are
certified
getting
copy
completely distracted को पैराग्राफ ता आपण चाहउछन्ती मॉडिफिकेशन से पैराग्राफ ता प्लेस करंतु आपण याडू सब कोन
certified copy रे
करंतु सेटा को सर्टिफाइड कॉपी
3/12
को अनेक्सर को पेज
annexer ହେଲା ଏଇଟା ଆଜ୍ଞା annexer ହେଇନି
अच्छा के कोर्ट रे परियो
आइए
you cannot pray the supreme court to correct a high court order to correct a court of district judge court of CJM को प्रेयर करिवे तापर because he is the supervising judge सेमती जो कोर्ट इशू करछन्ती सेठी हे परियो आपण सर्टिफाइड कॉपी नै जिबे substituting that or you can get another certified copy after correction and take it back don't make a prayer for correction of a order passed by another court it cannot be done you are sure that you are not seeking a modification of any order of high court or you are seeking press करंतु नि ताले if you have filed application for seeking modification of order or correction of typographical error by the Lorded court so and so not high court that cannot be done here okay yes list in the week commencing 6/4 आसले हबो
आज्ञा
6/4
ट्याग रे कि आउ गोटे सेम पिटिशन टीआरपीसी फाइल करछि सेटा हला
टीआरपीसी
the matter the
425
it is submitted by the Lorded counsel for the parties that TRPC
425
2025 same petitioner
425 of 2025 has been filed by the petitioner say Lakshmi Priya file करछन
आज्ञा आज्ञा
petitioner which is pending disposal pending consideration before this court on the next date the said TRPC the said TRPC shall be listed along with the present TRP CRL. Yes. 536 डाकी दो असले केबे डेट कोन तुम
हमर डेट
6/4 वीक कमेंसिंग 6/4
ओब्लिस्ट
say petition ता भितरे there is a purpose 6/4 you get the order corrected there and get another certificate copy
लिस्ट चेष्टा करथि लिस्ट वाला कहले असाइनमेंट चेंज हे जाईछि तेणु
एठी चेष्टा करछन काई की आपण जो सर्टिफाइड कॉपी आनिछन भूल अछि सेटा सेठी चेष्टा करिवे यदि भूल सर्टिफाइड कॉपी रे किछि भूल अछि
आज्ञा
आपण एटा को एप्लीकेशन दे कि नेबे सब्स्टिट्यूटिंग दैट विथ ए फोटोकॉपी सेटा नै कि सेठी देबे करेक्शन करिवे नहले आ गोटे करेक्शन पे अप्लाई करी सेठो आनिबे ठीक एटा either way because once you are getting a certified copy there is no difficulty जहाँ आपण भाविए करिवे
obliged.
yes item 36 madam what is the date by which date admission
Monday, Your Lordship.
eh?
16th of March, Monday, Your Lordship.
अच्छा माने by 16th you will complete the admission
We will try, we'll have in contact
Okay.
with
you try yours you can also try to intervene and get it sorted out.
Yes, Your Lordship.
There is nothing in the litigation for the parties to come to court. This is a classic case where no adjudication is necessary. Nothing adversarial. The admission process shall be completed as stated by the allotted counsel for the opposite party upon instruction by to लिखने sentence and change कर दिया तो by 23/2026. Yes, fair enough, Mr. Patnaik.
Okay.
Now at least
So তাহলে next date টা 23 को পড়িব
the matter shall be listed in the week commencing. आपनकर 23 week रे कोन matter specific adjournment अछि तासिरे matter अछि कोदुर गोटे आनंतु कोदुर आनिबे
25 दिन
week matter shall be listed on 25/3/2026.
सर 25 रे मोटे काम रो सर ता पर वीक रे पके दियंतु 30th
30 week छुट्टी गुडे अछि
सर
so there is a difficulty there are only 2 working days as it shows
sir 2 is okay
2 टा रखंतुनी you will have difficulty
ताले 6th
आपण 30 31 रे रखिबे नहले 6 रे रखो
6th is okay
6th week रे रखंतु केबे रखि
good
7/4
Mr. 7/4
again
Mr. at 2 p.m.
Yes,
and you ensure that the child is getting admitted so
Yes,
that the
sir.
child will have a future.
yes, Your Lordship.
Yes. खेलने पे भी allow करंतु apprehensive होंतुनी because someday the child has to go out of the home. He will grow up. He will outgrow his infancy. You explain these things. Yes. Next.
Much obliged, Your Lordship.
Pardon my lord. ଏଇଟା ଆଜ୍ଞା ହାଇକୋର୍ଟ ଅର୍ଡର ହେଇଥିଲା ଜଷ୍ଟିସ ଏସ୍.କେ. ମିଶ୍ରଙ୍କ କୋର୍ଟରେ ସେଇଟା ମୁଁ ପ୍ରେସ୍ କରିଥିଲି ମୋଡିଫିକେସନ କରିଥିଲି
से जो ओटा कहउचंती सेटा
ଆଜ୍ଞା ଆଜ୍ଞା
सेटा ऑर्डर ता बते तो आपन को स्ट्रगल कली 10 मिनिट डेटा ऑर्डर पैराग्राफ ता पाया पई पण कोन तो सेटा देखि मते मो पारे सब अछि मो पाखरे
पारा 6 कहली बा पारा 6 ऑफ द ऑर्डर पा कहउची
और आइटम ता केते
आइटम 21
21
पारा 6 आज्ञा एठी अछि
अरे मो पाखरे अछि आपन देखिया दरकार
हाँ, para 6 as an interim measure, liberty is granted to petitioners to move an adjournment in DB Miss case number 166 of 2025, now pending in the court of London Judge Family Court. এই जो Family Court লেখা আছে আগে এটা
सेटा the honorable coordinate bench कोठ आनिले सेटा आपण कोन पिटिशन रे कोन लिखछन सेटा देखांतु
petition
कॉस्ट टाइटल रे पढंतु
post title টা ভুল ଅଛି পা
बढ़िया
post title an application for transfer of DB Miss case number 166 2025 pending in the court of the London Judge Family Court.
So coordinate bench and not this bench cannot change your petition. You must understand. It is a matter of record. So तापर भीतर देखंदी पारा 2 देखंतु पारा 2 6th लाइन देखंतु
এটা পারা 2 রে জজ এসডিজিএম কোর্ট যাজপুর টু এসডিজিএম কোর্ট পুরী এটা ঠিক আছে
সেটা ঠিক আছে
আজ্ঞা
আর কোটি ভুল কি ঠিক লিখছেন দেখন্তু पारा 3 लास्ट पारा 4 ऊपर लिखछन एसडीजीएम जाजपुर
पारा 3 ର पेज 3 ର पारा 2 ରେ ଲେଖିଛି ଯାଜପୁର
सो तापर जोटा आपण को करन कोलिग आपण को कहिले ही टोल्ड यू दैट आपण ताको सुनिलेनी जे आपण अमेंडमेंट कला परे सेटा को ए प्रयासटा करिवे ଆପଣ amendment ତ କରିନାହାନ୍ତି
କରିଛି ନା
କାହିଁ ସେଟା application ଦେଇନାହାନ୍ତି so ବର୍ତ୍ତମାନ ସେ କଣ କହିଲେ ଯେ ଆପଣ amendment କଲା ପରେ
amendment
ସେ ସାର୍ଟିଫାଇଡ୍ କପି ଯଦି ଆପଣ
amendment ଆଜ୍ଞା କରିଛି 117 ଆଇଏ
application ଫାଇଲ କରିଛନ୍ତି
ଆଜ୍ଞା
amendment allow ହବ
ଆଜ୍ଞା
consolidated corrected petition file ହବ
consolidated ଫାଇଲ କରିନି
କେମିତି କରିବେ ସେଟା ତ ଜୁଡିସିଆଲ ଅର୍ଡର ହବା ଦରକାର
ଆଜ୍ଞା ଆଜ୍ଞା
ସେ କହିଲେ ମତେ କପି ଦିଅନ୍ତୁ ଦେଇନାହାନ୍ତି ଆପଣ ତାଙ୍କୁ କପି ଦେବେ
ଆଜ୍ଞା
ସେଟା ମୁଭ କରିବେ ସେଟା ଆଲାଉ ହବ ଆଲାଉ ହେଲା ପରେ amendment ଆଲାଉ ହେଇଗଲେ ଆପଣଙ୍କର ସେତେବେଳେ ମୁଭ କରିବେ କରେକ୍ସନ ଅଫ ଟାଇପୋଗ୍ରାଫିକାଲ ଏରର ଯୋଉଟା
ଆଜ୍ଞା।
ଆପଣ କହୁଛନ୍ତି ବଟ୍ ସେଠି ଆପଣ କନଫ୍ୟୁଜ ହେଇଗଲେ ଯେ ଆପଣ କହିଲେ ଯେ ସେଟା ଟ୍ରାଏଲ କୋର୍ଟ ଅର୍ଡର ବୋଲି
ନାଇଁ ନାଇଁ obliged
ସେ ତ କେସ୍ ପେଣ୍ଡିଂ ଅଛି କହିବେ ବଟ୍ ୟୁ ହାଭ୍ ଟୁ ଫାର୍ଷ୍ଟ ପ୍ରିପେୟାର ଦ ଆମେଣ୍ଡେଡ ପିଟିସନ ଅଲସୋ ନହେଲେ ସେଥିପାଇଁ ଆହୁରି ମାସେ ନେଇଯିବେ ୟେସ୍ ନେକ୍ସଟ
22.
May it please your lordship. I am for the appellant.
Yes, please.
I am for the appellant, my lord. The present appeal has been prepared under section 54 of the Land Acquisition Act. And today I listed for consideration of the petition for exemption of 40, my lord. The appellant has filed his income certificate and it is available at page 41, which shows that he has.
Have you served copies, Mr. Devata? Have you served copies?
Yes, yes.
Yes, my lord.
Have you obtained instruction or you'll obtain instruction?
No, I have not.
So you obtained that. Mr. Devata, actually today, yesterday, same thing happened actually. I am told that some technical issue is there, it is happening in every court, but today at least your voice is audible. Could you hear Mr. Mahanti? He says that he'll obtain instruction in response to the IA.
Yes, my lord.
Yes, yes. Mr. Rabindranath Devata for the appellate. So Prem Kumar Mahanti for the OP number 1 and 2. The first detail that tag is IA number 29 of 2026. Plus, the IA has been filed filed under Chapter 6, Rule 27 into bracket A of the Odisha High Court rules. Arising out of the land acquisition appeal under Section 54 of the Land Acquisition Act 1894, challenging the judgment and award dated 12/5/2025, 12.05.2025, passed by the Learned Civil Judge Senior Division, Sambalpur, in LA case number 46 of 2015. Referring to the averments made in the IA, it is submitted by the Learned Counsel for the appellant petitioner that he may be exempted from payment of court fee. Copy of the IA has been served on the Learned Counsel for the Additional Standing Counsel. Learned Additional Standing Counsel shall obtain instruction for which he prays for 4 weeks time. The matter shall be listed for orders in the week commencing. So, Barik. 24-26. Week commencing 24-26.
Yes, my lord.
Then second matter same.
Same, my lord. But the IA number is different. It is
Correct. So IA, LA, all those will be details should be changed. Secondary copy by Mr. Mahan.
Yes.
Copy of the IA has been served on the copy of the IA has been submission for it. Copy of the IA has been served. Had Learned Counsel for the petitioner. Copy of the IA has been served on the Learned Additional Standing Counsel for the state.
My lord, in the second item, the judgment date and the LA case number.
Yes, yes, it has to be. It has to be. Yes.
Okay.
Yes.
Item 23.
Item 23, may I please, Your Lordship?
Mr. Contempt Mishra for the petitioner.
Lordship may come to order dated 10/3/2026. Lordship had listed it today for orders. We have filed an IA, Your Lordship, for stay of the trial being conducted at the family court.
To Gautam Misra for the petitioner, opposite party blank. एमती आ गोटे मैटर थिला सेटा कोन लिस्ट हेई पाले तो आपण ऑर्डर पई जेटा दस्खत पई रहितला ना कोन आ दुटा मैटर थिला एमती एटा गोटे आ गोटे भी थिला तो बिजी ठीक अछि आईएटा ऊपर रखियो सब बळे कंफ्यूजन हो आईएटा ऊपर रहबा ता तळे रहबा अरेंजिंग आउट ऑफ
Yes, sir.
I got confused. IA number 78 of 2020, by order dated 10/3/2026, notices were issued by this court. The returnable date has been fixed to 31/3/2026. Upon a requisite file, have you filed requisites?
Today we have filed, Your Lordship.
It is submitted by the learned counsel for the petitioner that requisites for issuance of notice to the opposite party as directed by the order dated 10/3/20 have been filed today. Para. IA 78 of 2026. The IA has been filed seeking
Stay of further proceedings.
stay of further proceeding of the CP number 73 of 2025 pending before the Learned Judge Family Court Rayagada during pendency of this petition. Higher Learned Counsel for the petitioner, he reiterates his submissions as noted in the order dated 10/3/2026. Issue notice as above. You are filed today or you will be filing?
We will be filing.
Okay, okay.
Yes.
As above. Notice to the opposite party shall be issued along with the notice issued in the TRPC, except one set of process fee as well as postal requisites. How much time diya itla?
7 working days.
Okay. So it is there or it is over? 10/7
No. It is there, Your Lordship.
Okay. The requisites shall be filed together along with the TRPC. As an interim measure, it is directed that the CP number so and so pending before so and so shall be adjourned to a date beyond date beyond 13/4/2026 as would be convenient to the learned judge, the learned court in season of the matter. The matter shall be listed for orders in the week commencing 6/4/2026. And the adjourn beyond it upon a prayer being made on that behalf for the said purpose. Yes, next.
Item 24.
May I please?
So Pramod Kumar Misra. For the petitioner. By order dated 10/3/2026, notices were issued. IA 79 of 2026 has been filed by the petitioner seeking interim order. IA 79 of 2026 इतने लिखते हैं and the counsel for the petitioner. Staff he reiterates his submissions as noted in the order dated 10/3/2026. Issue notice. Staff notices shall be issued along with the TRPC as directed by order dated 10/3/2026. Except one set of process fee as well as postal requisites. As an interim measure, it is directed that the pending proceeding CP number criminal proceeding number 109 of 2025. The record and the CP or transfer. The CP number 275/25 pending before the Learned Judge Family Court Jagat Singhpur shall be adjourned to a date beyond 13/4/2026 as would be convenient to the learned court in season of the matter upon a prayer being made for the state purpose. Stop. The matter shall be beyond 14. The matter shall be listed in the week commencing 13/4/2026.
Obligation.
Mr. GN Perda. To GN Perda for the petitioner. Mr. Samik Kumar Misra, senior advocate, Mr. Mansuman Sethi, additional standing counsel for opposite parties 1, 2, 1, 2, 4, 427. देखिए लिखिए जहाँ appearance से share होगा. Mr. Mansuman Sethi AC. Mr. Samik Kumar Misra, senior advocate, along with Mr. SR Behra for OP number. Corporation to likhime. It is submitted by the Learned Counsel, Mr. Perda, for the petitioner that the order dated 17/2/2026 passed in IA number 2932 of 2026. At paragraph 16, directing payment of rupees 50,000 by 5/3/2026 has been complied with. Office note dated 7/3/2026 indicates that the deposit has been made and the amount has been deposited in Union Bank of India. VDA account number देखिए लिखी देवे इतने और 7/3/2026. In view of the compliance of the condition imposed by this court for passing of in view of the condition imposed by this court for passing the interim order stands compliant with. The matter is adjourned, shall be listed in the week commencing 13/4/2026. Interim order has passed. Interim order dated 17/2/2026. 17/2/2026 shall continue till the next date of hearing. Yes. Rest of the matters cannot be taken up due to paucity of time. If you want any date, particular date, you can take.
My lord, I may be permitted. I mean, wish you lordship.
Yes, Mr. Satpathy. So I have some difficulty because I have to attend something, so there is a time actually.
My lords, I am not pressing any matter. Item 32, my lords, because the matter is posted tomorrow before the London Family Court, Bhubaneswar.
We are appearing on
Instead of making payment, they are coming and they
Yes,
are
32.
coming to the court and they are submitting that the case is pending in the High Court, so we will not pay in execution.
So 32, better you take a date and let them do that mistake again. So it will be aggravated further.
No, your lordship, last
So if they are not paying and the execution has not been stayed and they are taking that plea, let us. So today nothing can be done. You take a date.
your lordship next date no 19 को in the before the London judge.
It's important no. अपन जो कोचों High Court stay करने आने के এবং stay नहीं चलती execution नहीं करूँगी.
We are not stating anything
So
like
this
that.
court is the last court to tolerate.
If we are nothing, we are not stating
So
anything.
you comply the order. सेठी important. आपण कौन कहूँचो important हो. आपण whether you are respecting the decree. It is interim payment. Lump sum तो no.
On 19/3.
आपण दियंतु पैसा दे. आपण दियंतु पैसा. सेमती काहे करचोंदी.
Pardon, my lord. Item 30. I am for
please appreciate this. There is paucity of time. Already, in fact, we have reached the end of the day's proceeding. So for the dates, I cannot remain to know because I have something to attend. So you take a date. 30, what do you want actually?
I have filed the objection and I am supplying today to the objection.
I cannot record. It's no difficulty. I cannot record any further. Please.
My lord.
Yes.
The lordship 32 टा week commencing 24th 24th.
आपण जोडे agree करंतु सब जिंस छाडतनी कोर्ट ऊपर. You are also officer of the court.
We will decide.
Yes. You decide and you give in the date, Mr. Satpathy. Your learned colleague is suggesting a date. If you agree, then you tell her.
Item 30 टा interim order तक.
No, not tomorrow. Tomorrow it's not possible to list matters because already the list is complete.
Today they have solved the interim order touched the date.
Interim order not any na. Interim order is not being touched. Please appreciate that. No order is passed.
Then my item 30.
39
million.
Date नहीं हो तो 39.
39 ले मैंने तो माइनर सोन ता मदर जाइथिल ता घर को तार एग्जाम बर्तमान चली घरे एंट्री कर देलेनी कि तार कोनोसी बुक्स तार एडमिट कार्ड किछि ताको देलेनी बहुत कष्ट से आनछि प्रोटेक्शन कोड
कोन करियो unfortunate child when somebody is acting as the interest of the child what can be done you take a date.